Court officer. Court officer.
ರಾಯಚೂರು ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಕೇಳಿಸ್ತಾ ಇದೆ ಅಲ್ಲ? ಸಾಕು.
ಕೇಳಿಸ್ತಾ ಇದೆ ಕೇಳಿಸ್ತಾ ಇದೆ. ಆಲ್ಟರ್ನೇಟ್ ರೆಮಿಡಿ ಅಂತ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ. ಅದು ಯಾವ ಪ್ರೊವಿಷನ್ ಅನ್ನೋದು ಹೇಳ್ಬಿಡ್ಬೇಕು. ಅದೊಂದು ಹೇಳಲ್ಲ. ಅದು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಬಂದಿದೆ, ಅದು ಇಮಿಡಿಯೇಟ್ ಕಳಿಸಿ ರಿಟರ್ನ್ ತರಿಸಿ. ಅಲ್ಲ ಬ್ರಾಂಚ್ ಕಳಿಸ್ಬೇಕು, ಅದು ಅಪ್ಲೋಡ್ ಆಗತ್ತೆ, ಕೊಡ್ತಾರೆ ಕಾಪಿ, ಆಮೇಲೆ ರಿಟರ್ನ್ ತರಿಸ್ಕೋಬೇಕು. ಮಾಡ್ಯಾರಂತ ಹಾಂ ತರಿಸ್ಕೋಬೇಕು. ಅವರು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತಾರೆ. इधर रहना फैन कर बोले तो फैन ऑन करके जाना ना कुछ ना बाहर आए नहीं गारंटी ये वन स्टेट इन
ಹಲೋ, ಇದು ಒಂದು ನಂಬರ್ ಫೈಲ್ ಕಳಿಸ್ತೀನಿ ನಾನು, WP109949/25 ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಮ್ಯಾಟ್ರ್ ಇದೆ. ಇದು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಅಷ್ಟೇ ಟೈಪ್ ಮಾಡಿ ಕೊಟ್ಟಾರ. ಅದನ್ನ ನೀವು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿ ಇಮಿಡಿಯೇಟ್ ನಂಗೆ ವಾಪಸ್ ಕಳಿಸ್ಕೋಬೇಕು, ಪೋರ್ಟಲ್ಗೆ ಕಳಿಸ್ಬೇಕು. ನಂಬರ್ ಬರ್ಕೊಂಡ್ರಲ್ಲ? ಹಾಂ ಹಾಂ, ಆಫ್ 25 KT
इसको फर्स्ट यूज करते हैं ना,
पेंसिल
ये इधर ही रहने दो सर, ये दोनों इधर रहने दो। एक बार निकल के उसको पूरे रखते हैं, बस बस बस।
ಮೇಡಮ್ ಮೊದಲು ಕೊಟ್ಟು ಹೋಗ್ಬೋದು. ಎಲ್ಲ ವಿಷಯ ಇಲ್ಲಾಂದ್ರೆ ರೆಗ್ಯುಲರ್ ಮೇಡಮ್ ಆನ್ಸರ್ ಮುಂದುವರ ಹ್ಞೂ ರೀ ಹ್ಞೂ ರೀ ಏನು ಆ ಥರ ನಮ್ಗೇನು ಹೇಳಿಲ್ಲ. ಅವ್ರಿಗೆ ಕೊಡ್ತಾರೆ ಮೇಡಮ್ ಕೊಡ್ತಾರೆ. ಟೆನ್ಷನ್ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ. ನಿಂದ ನೀವು ಕೊಡ್ತೀರ ಅಲ್ಲ, ಭಾಳ ಮಂದಿ ಕೊಡ್ತಾರೆ ಲಾಸ್ಟಿಗೆ. ಟೋಟಲ್ 7 ಕೊಡ್ತೇನೆ ಹೆಂಗೈತೆ ನಮ್ಮ ಸಭೆಗೆ ಕೊಡೋದು ಹಂಗ ಯಾರ್ಯಾರ ಬಂದ್ರೆ ಜೈ ಅನ್ಸೋದು ಹಾಂ ಇವತ್ತು ನಡುವಿನ ಶುರು ಮಾಡ್ತಾರೆ ಬಾಜು
ಯಾಕ್ರಿ ಗೊತ್ತಾಗ್ತಿರ್ಲಿಲ್ಲ ನಮ್ಗೆಲ್ಲ ನೋಡಿ ಬರ್ಲಿ ನಮಗ್ ನೋಡ್ರಿ ಎರಡು ಇಲ್ಲಿರೋ ಅಂತಂದ್ರೆ ಫ್ಯಾನ್ ಹಚ್ಚಂತಂದ್ರೆ ಹಚ್ಚಾಕ್ಬೇಕು ಹೌದಲ್ಲ ಫ್ಯಾನ್ लगाने बोला तो ಅಣ್ಣಾರ? ಏ, ಇದು ಮಾಡು. ತೆಲಂಗಾಣ ಹೈಕೋರ್ಟ್ ಕಳಿಸ್ಬಿಡ್ತೀರಿ ನೀವು. ಕಲಾವಿತಿಲ್ರಪ್ಪ.
ಬಂದ್ ಆಪ್ಷನ್ ಇಲ್ಲ.
Two matters to be listed. They have not listed. Huh? Huh. Please file your written arguments. And those matters, why they are not listed? Did they ask those matters to be listed? Let it come on Monday. It will come on Monday.
Fresh code.
No, what you can do is on Monday when those two matters come, you can make your submissions on that day. Apart from filing your written arguments, we'll look at it. All those reserved matters also, let that also be listed tomorrow along with those matters.
My
Yes.
lord.
Labor matter, Madam Lordship.
Which year?
Last day for yesterday I have filed.
Fresh matters, I asked you to give the memos.
Today it was supposed to be listed. There was a late in compliance, so tomorrow it is very urgently because show cause notice has been issued.
Tomorrow, yes.
Well, it's one election matter, it had become infructuous matter. Infructuous matter.
Yes,
we can.
That is on Monday.
My lord, one.
2018 matter, the appellant has died, need to take steps.
2018 matter, MFA.
Yes, Your
We'll,
Lordship.
next week we'll give one full day for the MFAs. The old matters will come.
Any day
Yes,
next.
we'll see.
My lord, one writ petition, we are for respondent. We have filed IA for vacating stay. The petitioner, by suppressing the second compromise, has obtained the interim order before this honorable court. Please,
Take it, someday we'll accommodate next week. Yes.
My lord, one matter for the preliminary hearing, B group, by virtue of the interim order obtained by the government, my lord, the petitioner is not getting the gratuity amount, my lord.
Which year is the writ?
2024, my lord.
We'll see 24, not let's,
My lord, at
let's
least
complete this rush of
next
25.
next week, any date, maybe.
We'll
Next.
see. Take that, we will see. Yes.
One matter for election matter, my lordship.
On matter?
Election matter,
Ah.
cooperative society election matter. Election is already conducted, only for announcement of the result for orders.
It's filed? When is it filed?
Already election is also conducted, only for pending for announcement of the result.
Next week, yes.
One matter for vacating stay, tender matter, my lords.
Take it, next week.
One matter for election, my lord. Election is already conducted, my lord.
Next week.
Date.
GM work, my lord.
GM?
Work.
Ah.
My term is remaining only 6 months, my lord. I have been suspended. I am mutually, my lord. Any specific date?
A week thereafter. Yes. Call the
Lordship,
list.
one matter, Lordship, LAC matter. Withdrawing the depositing amount, Your Lordship.
What is that?
Withdrawal of the deposited amount.
Huh? We want to withdraw the amount.
Next
Yes,
week.
Tuesday.
My lord, I am a respondent. The respondent is 82 years old woman, domestic violence matter. In view of the stay order, she is unable to get a residential order at the trial court. The matter is stayed.
Matter. What is it? How is it numbered? Writ
It's a
petition?
WP, Your Honor.
WP? Family court?
Writ petition is filed wrongly without, in fact, it is criminal matters, but they have raised jurisdiction of the writ petition. I am respondent in this matter.
Next week. Yes, call the list.
Next.
number 1, page wise adjournment, page number 1, serial number 1 and 2, page number 2, serial number 3 to 6, page number 3, serial number 7 to 9, page number 4, serial number 10 to 14.
Serial number 10, it can be referred to media Lok Adat, not already mentioned in the court.
Of the counsel for the appellant, this is matter for the Lok Adalat.
Right.
Yes.
Page number 5, serial number 15 to 18. Page number 6, serial number 19 to 21. Page number 7, serial number 22 to 26.
Lord, serial number 23. I am appearing on behalf of Mantesh R. Patil, my lords. His relatives, my lord, is expired.
Appearing on behalf of?
Mantesh R. Patil, petitioner counsel, my lord. Lord, his relative is died, my lord. Therefore, he is not in station today. There is some
Inform the
urgency,
other-
my lord. Tomorrow, you may request.
From the other side?
Please, my lord. No. He called and informed to others.
We'll have it next week.
Lord, tomorrow. He is not other side counsel.
You inform the other
Please,
side.
please,
counsel?
please.
Yes, at the request.
Tomorrow, my lord, some
This is
urgency.
matter tomorrow.
Please, grateful, my lords.
Lord, serial number 25, my lords.
Yes.
Long date, my lords, because senior has cancer surgery, my lords. Serial number 25, my lords.
This is matter in the month of March.
Please, my lords.
The request of counsel for the petitioner. Appellant, yes, next.
Page number 8, serial number 27 to 35.
Give that.
Page number 9, serial number 36 to 44. Page number 10, serial number 45 to 47.
With your lordships kindly, my lord. Serial number 45.
Yes.
My lord, I have informed the other side any date next week, my lord. This matter pertains to sugar season 23, my lord.
The request of counsel the petitioner, this matter on 9th of February, it is submitted that they've already informed the counsel from the other side.
Grateful.
Yes.
Page number 11, serial number 48. Page number 12, serial number 49 to 53.
Serial number 49, my lords. I have informed the other side, my lords, week's accommodation, my lords.
Yes,
yes, Coach.
Interim order may be
A week's time. In all these matters, interim order is there.
Great.
Serial number 50, my lord. I undertake to file, serial number 50, my lord. I undertake to file wakalat for respondent, my lord.
Interim order kindly be extended, my lords.
Yeah, the request of learned counsel, so and so submits that, write your name on the.
Please, my lord.
Submits his instructions to file wakalat on behalf of the respondent. It's this matter on 24th of February. The interim order earlier granted is extended till then. Yes.
Please.
Call the list.
List number 1, orders matter, serial number 1.
I appear for.
I am for the respondent.
Lord, I appear for the petitioner. The office has raised objection that since the Waqf Tribunal Kalburgi has passed an order, the maintainability is the point that has been raised by the office. Lord, the subject matter of the property is situated within the district of Koppala, which comes within the jurisdiction of this honorable court. And the
See, what is the maintainability? Post MF.
serial number 3, my lord.
My lord, senior counsel is appearing in this matter.
But I appear for
Senior counsel is appearing on behalf of respondent.
Yes. It is a Waqf Tribunal Kalburgi division.
Yes, my lord. Since the property is situated at Koppala, my lord.
Then why was it before the Kalburgi division?
My lord, since in respect of certain districts, my lord, one tribunal is constituted. Lord, for Koppala, Raichur, and certain districts, my lord, the Waqf Tribunal Kalburgi has got a jurisdiction. In respect of Belgaum, certain districts are provided, but that will not, my lord, curtail the jurisdiction of this honorable court, where the subject matter of the property is situated, in respect of which the Waqf Tribunal Kalburgi has declared this as a Waqf property.
No.
Please, Lord.
When the Waqf Tribunal at Kalburgi has done it, why can't it go to the Kalburgi,
No.
the bench at Kalburgi?
Lord, since the cause of action arose, my lord, in the jurisdiction of this honorable court, since the property is situated at Koppala, my lord. And the petitioner is a resident of Koppala, my lord, and this honorable court has jurisdiction, my lord. The same issue, my lord, had come before this honorable court. A maintainability objection regarding maintainability was called in question. The order dated 7/6/2022, my lord. I have put a, my lord, a flag on the particular date, my lord. May I read, my lord?
Yes.
Learned counsel for the contesting respondent 6 to 8 submits that this petition could not have been filed before the Dharwad bench since the entire cause of action behind the order of attachment passed against the petitioner was at Bengaluru, and therefore learned counsel submits that this matter may be transferred to the principal bench. Learned counsel for the petitioner, on the other hand, has drawn the attention of this court to the impugned order at Annexure C passed by the Deputy Commissioner, Bengaluru District, which is based on the information provided by Regional Transport Officer Dharwad in his communication dated 16/5/2014. It is submitted that the petitioner carries on his business at Hubballi, Bengaluru and Goa. Bengaluru is in respect of transport vehicles belonging to the petitioner registered in the Regional Transport Office at Dharwad. In terms of the recent judgment of the full bench in the case of Karnataka Power Transport Corporation versus Gopal Krishna, reported in so it is sufficient if a person who approaches any of the benches of this court to show that a part of cause of action arises within the jurisdiction of said bench. Therefore, when the petitioner is being able to point out some of the orders and fact that transport vehicles belonging to the petitioner registered at Dharwad have been attached by the impugned order, the petitioner is entitled to file the petition before this court. So if it is sufficient, my lord, that the cause of action arose, my lord, before this honorable court, since the property is situated.
This issue is altogether different.
Lord.
It's altogether different. This is with regard to a vehicle that has been registered.
No, my lord. In that case, my lord, what had happened is order of the Deputy Commissioner Bengaluru was called in question before this honorable court. And the office has raised objection that the petition has to be filed before Bengaluru bench. Lord, since the information relating to the transport vehicles are registered within the jurisdiction
We'll
of.
see this. We'll
Please.
see.
Please.
Yes, Mr. Smart on Tuesday.
30. Cell number 2, Vishwanath Bhatt. CB Shakunwalli.
Notice to R9 returned as unclaimed and notice to R10 returned as refused amounts to deemed service of notice. The petition shall furnish the process for issuance of notice to R11 within a week, or else the petition shall stand dismissed against respondent and number 11. List, yes.
Interim order may kindly be extended, my lordship. Interim order may kindly be extended.
Interim order earlier granted is extended. Yes.
Cell number 3.
Well,
Shurajas
for
Malloli.
petitioner in this
Your
I'll take
Lordship.
fresh steps for R2.
Huh?
For respondent number 2, I'll take fresh steps.
Your Lordship, I will undertake to file wakalat respondent number 2 and 1 and 2, my lord.
1 and 2.
Please.
So and so submits that. His instructions to file wakalat on behalf of respondent number 1 and 2.
And
Ready?
my lord, no, I will file objection, my lord. 2 weeks.
What objections for this? This matter.
This is a
interim
low
order
adalat
can-
matter, my lord.
This
Compromise.
matter, you have an interim order?
Yes, kindly be extended.
List this matter on, list this matter in the month of March. Interim order earlier granted is extended till then. Yes, court.
Oblige.
Number 4, Saurabh Hegde, SV Deshpande.
Petitioner, my lord.
Awaiting.
My lord, notice to R2 and 3 may be dispensed, my lord, because
Where is the memo?
Lord, I will file a memo to that extent, my lord, the counter, but they were just sureties, my lord. R1 is the contesting respondent.
In the same for respondent 1, you are my lord. Respondent number 1.
You can give a memo right now.
Please.
Yes. You're ready to argue?
My lord, I request my learned friend to file a memo of calculation because it all depends on the calculation memo, my lord.
Yes.
Already we have filed memo of calculation.
List this matter on 18th of February at the request of front counsel for the petition. Next. R5, list after service of notice. 6.
My lord, I have the benefit of interim order, my lord. Might
No,
be
wherever it is, it will be extended.
Wait.
Yes, 6.
Cell number 6, GB Padiger. Yes,
I filed memo for withdrawal, Your Lordship. Yesterday I filed the memo for withdrawal and I have moved the memo, Your Lordship. It has not been moved. It has been not put up, Your Lordship. The liberty to approach before the DRT, Your Lordship.
The memo is filed, so we withdraw the petition with the liberty to approach DRT. Accordingly, memo is taken on record and the petition dismissed as withdrawn with the liberty.
Within 2 weeks, we will approach. Within 2 weeks, we will approach before DRT.
It's an interim
For the
order,
purpose of retention, Your Lordship.
There is an interim order in this.
No, no.
The petition shall approach the tribunal within 2 weeks from today. And the issue with regard to the limitation is kept
much
open.
Much older.
Yes.
Hearing on IE, seal number 7. Shanapes Koliwat.
I have filed application, my lord, paper publication for R4, my lord. Gangavati edition, my lord.
Give the dates.
Please.
I number 1025 is filed.
Please.
For the substituted service of notice on respondent number
4, my lord. Please, my lord.
Respondent number 4.
Please.
Accordingly, I number so and so is order. Petitioner shall take out notice, substituted service in Vijay, Karnataka, Gangavati edition, hospital, mentioning on or before so and so, mentioning the date of hearing, so and so. Yes, next. Next.
Your
Number
Lordship,
8.
in this matter,
Srikant Reddy.
we have preferred an appeal, Your Lordship. This is a very peculiar case, Your Lordship, wherein I have to argue against myself only. Because liability is, we have challenged the liability. Vehicle belongs to Forest Department, Your Lordship, government. And liability is fixed upon both, Your Lordship, Forest and KGID, which is insurance company. But wherein policy is also already expired. At the time, after expiry of the policy, Your Lordship, accident was taken place.
Then it's your responsibility.
Again, both
For 2 vehicles, 2 departments.
2 departments, because it is a dispute between 2 departments, Your Lordship, now. As in second matter, Your Lordship. In first matter, they have challenged for enhancement, Your Lordship.
Then we'll hear it.
Your Lordship, there is a delay of 380
We have
days.
filed objections. Objection, I have filed, Your Lordship, for 380 days, Your Lordship.
I number 10/2023 is filed to condone the delay of 380 days. The respondent will file the objections for the reasons stated in the accompanying affidavit. The delay is condoned on the condition that they'll not be entitled for interest for the delayed period in case of enhancement. Yes. I number next in 8.1, I number 1022 is filed to condone the delay of 35 days. Condone. Ready to argue?
Your Lordship, please, Your Lordship. Please, Your Lordship.
Yes. You are on liability.
Please, Your Lordship, I am on liability, Your Lordship, because, but one more thing, Your Lordship, as there is a dispute between 2 departments, Your Lordship, dispute resolution policy is there, Your Lordship, hence matter is to be referred to the secretary, principal secretary, Your Lordship, to resolve the dispute, Your Lordship, as per the policy. Dispute resolution policy in the
No. Why are we concerned with all this dispute resolution policy?
Because
Now,
as
two
please,
as it is adjudicated by the tribunal.
Please, Your Lordship.
Yeah, it find fault with 2 vehicles.
Only 1 vehicle, Your Lordship. Vehicle is 1. Vehicle belongs to Forest Department, Your Lordship. And KGID is the insurance department policy company, Your Lordship. KGID also belongs to the government, Your Lordship, and Forest is also government.
You say that there is no insurance as on that day.
As on the date of accident, there was no insurance.
Then
Because Forest is also, I have to represent Forest as a government, Your Lordship. I have to represent.
Is filed by whom?
Appeal is filed by the respondent number
Forest
KGID, insurance policy.
Come to that finding.
Please, Your Lordship. Para number 15 and 17, Your Lordship. Of the
Para number?
Para number 15 is the quantum, regarding quantum, Your Lordship. Para number 17 of the judgment, Your Lordship, liability.
Please read.
Please, 17, Your Lordship. The respondent number 2 in the written statement contended that Bolero vehicle so and so is not insured with the respondent number 3. That is respond number 2 is the forest department, respond number 3 is the KGID insurance limited, your lordship, company. And the policy is covered from 22/12/2014 to 21/12/2015. As on the date of accident, policy is not covered.
What is the date of
Date of incident is, your lordship, 16/10/2014.
Yes.
So, Your Lordship, as on the date of accident, policy is not covered. As on the date of accident, the vehicle involved in the accident was used by the assistant conservator of forest, Hirur, and under the control of assistant conservator of forest, Hirur. Therefore, the respond number 2 is not liable to pay the compensation amount. Respond number 2 is a forest department, Your Lordship. The respond number 3 is a KGID motor branch, Bangalore, not appeared before the court and not contested the matter, which we have filed the appeal, Your Lordship, KGID against from the KGID. The petitioners have produced exhibit P7, judgment of MVC number 118 of 2015, which is connected to the same accident, and the liability is fixed upon the respond number 1 to 3 jointly and severally. In the present case on hand, even though the respond number 3 not appeared before the court and not contested the matter.
Full form of KGID.
KGID, Karnataka Government Insurance Department.
Your Lordships.
Government vehicles were
Time may, further
provided.
time may be given, Your Lordships. Further time may be given for this. Machinery will argue on this matter.
You don't worry, we'll take care of your, court will take, you don't have to argue, we'll see, yes.
The vehicle involved in the accident is also a government vehicle. And therefore, the court has opined that
No
the
matter, whoever pays the government will
government has to pay. That is
pay.
the
Come
only.
come to the enhancement. Where is the table?
Page number, para number 15, Your Lordship, quantum. Page number 23, Your Lordship. According to petitioners, deceased Subbaraj is so and so healthy person and was doing agriculture work, earning 4,50,000. To prove said contention, PW1 stated averments of the so and so Patta book regarding which was standing in the name of petitioner number 1. It appears that petitioners are having agriculture land of an agriculturist. Hence, looking to the year of the accident with regard to the income deceased, this tribunal considers 6,000 per month, Your Lordship. As per the PM report, which is exhibit P5, age of the deceased is 40 to 45.
Which year is the accident? 2000?
Year
2014.
Please, Your Lordship, 2014.
The income should have been 7,500.
Income of rupees 6,000 they have taken, Your Lordship.
Taken, but it should be 7,500 as per the table.
Please, Your Lordship.
So 7,500, what is the age?
Age 40 to 45, so multiplier 14 has
Not
to.
future prospects. Future prospects should be 25%. Future prospects would come to 1875 plus 7,500. It comes to 9375. How many are the dependents?
Four, Your Lordship. Wife, child, and father and mother.
One-fourth is 2343.
Please, Your Lordship.
It is 7032 into 12. What is the multiplier? Age is 45.
Age is 45, multiplier 14, Your Lordship.
45, 14 into 14. 7032 into 12 into 14. It comes to 11,81,376. Towards consortium, 4 into 44. That's 1,76,000. Funeral expenses 36,000. Legal expenses 10,000.
Funeral, 10,000 has been taken, Your Lordship. Funeral expenses, 10,000 has been taken by the tribunal.
It should be 36,000. So it comes to 14,03,376 against,
Against 7,86,000, Your Lordship.
you get it?
Page number 26, Your Lordship. The petitioner number 1 to 4 are awarded total compensation of rupees 7,86,000.
7,86,000. It will be 14,03,376. How come it has come?
Your Lordship, deduction is taken, Your Lordship, 1/4 income towards personal and living.
That's what, 7,500 is the income.
Please, Your Lordship.
25% future prospects would come to 1,875. That is 9,375. If you deduct 1/4, that is 2,343. Then his contribution to the family is 7,032 into 12 into 14 is 11,81,376. Towards consortium 4 into 44, 1,76,000. Funeral expenses
Funeral,
36.
please,
10,000 legal expenses.
Funeral expenses and.
No, it's a standard pattern.
Please,
It's
Your
not
Lordship.
something court is granting. Please come.
With regard to the liability. Your Lordship.
Liability is on the forest department.
Please.
It is, sir, you are representing them also.
Please, unfortunately.
The agreed with award passed in MVC number.
And the charge sheet is also filed against the
Forest Department.
Forest.
Agreed with award
Driver of
passed
the-
MVC number 11 of 2015, dated 12th November 2019 by the first additional senior civil judge, Ballari. The claimant is both the claimant as well as the case ID. KGID is before this court.
KGID is the only.
KGID is before this court.
Please, Your Lordship.
The appeal filed by the claimant is MFA number 10095 of 2023, and the appeal filed by the KGID is
That appeal is filed by the enhancement from the claimant. Please.
the appeal filed by the KGID is MFA number 102085 of 2022. The claim petition is filed seeking compensation of an amount of rupees 1 crore. An amount of rupees 1 crore for the death of the deceased in the motor accident that took place on 16/10/2014. It is a case of the claimant that on 16/10/2014 at about 3 p.m., the son of the claimants was proceeding along with another person. At the time, the respondent number 1, being the driver of the Bolero car, came from the opposite direction in a rash and negligent manner and dashed the motorcycle. As a result, both the rider and the pillion rider fell down on the road and sustained fatal injuries all over the body. It is a case that the deceased was earning an amount of rupees 4,50,000 per annum. The tribunal had granted compensation of an amount of rupees 7,86,000. Court has considered the income at 6,000. 6,000. Consortium is granted at 10,000. Loss of estate 10,000. 10,000 for the funeral expenses. Altogether, the compensation back 86,000 is granted. When it comes to the liability, it is the case that the vehicle is insured by KGID, and the insurance was enforced from 22/12/2014 to 21/12/2015. The date of accident is 16/10/2014. The vehicle belongs to the Forest Department. It is a contention of the KGID that as on the date of the accident, there was no policy there was no insurance subsisting, and as such, they are not liable to pay the compensation. The tribunal had considered the order that is passed in MVC number 118 of 2014, that is in respect of the other, he was a pillion rider or he is a rider?
No.
Who is the rider? This person or the other person?
He was a rider. Super rider was a driver, Your Lordship.
Super rider is a driver,
Oh, yes,
rider.
yes, Your Lordship.
In respect of the pillion rider, in MVC number 118 of 2015, the court has held that both the KGID and the Forest Department are joint and severally liable. As such, the court has held that even in this case also, both of them are jointly and severally liable. Next. Learned counsel appearing for the claimants submits that this accident had taken place in the year 2014. As per the table, as per the notional income fixed by the Legal Services Authority, the income ought to have been taken at 7,500. Further, the age of the claimant is 45 and he is entitled for future prospects at 25%. Court has failed to consider the same. Further, under the head of consortium, loss of consortium, funeral expenses, the compensation that was awarded is not a just and reasonable compensation. It is submitted that on all the counts, the compensation needs to be enhanced. It is also submitted that with regard to the liability, the court has rightly held that both the KGID and the Forest Department are jointly and severally liable, and there are no grounds to interfere with the appeal that's filed by the KGID. Next para. Learned counsel appearing for the learned the learned counsel appearing for the appellant in MFA number 102085 of 2022 submits that as on the date of the accident, there is no subsisting insurance policy. Hence, question of fastening the liability on the KGID is without any basis. It is submitted that as the vehicle belongs to the Forest Department, the Forest Department is alone liable to pay the compensation. It is submitted that the court had rightly considered and granted the compensation and there are no grounds to enhance the compensation. Next para. Having heard the counsels on either side, peruse the material on record. First, coming to the question of liability, both the KGID and the Forest Department or the government departments.
That is respond number 6, Your Lordship. Respond number 6 in our appeal.
Departments. Admittedly, there is no policy as on the date of the accident. Hence, as the vehicle belongs to the Forest Department, the Forest Department alone is liable to pay the compensation. Then coming to the enhancement of the compensation, the accident had taken place in the year 2014. As per the table fixed by the Legal Services Authority, the income has to be taken at the notional income has to be taken at 7,500. The claimant, the deceased, was aged about 45 years. 25% future prospects would come to 1,875. Then his income is 9,375. As there are 4 claimants, 1/4 has to be deducted towards his personal expenses, that is 2,343. Then his contribution to the family would be 7,032 into 12, and the relevant multiplier is 14. Then under the head of loss of dependency, he is entitled for an amount of rupees 11,81,376. Towards consortium, 4 into 44, 1,76,000. Towards funeral expenses, 36,000. In the light of the law laid down in Mekala versus so-and-so, the legal expenses, 10,000. Altogether, the claimant is entitled for an amount of rupees 14,03,376. Accordingly, the appeal filed by the claimant, that is MFA number 100951 of 2023 is allowed by enhancing the compensation from 7,86,000 to 14,03,376. And the appeal of the KGID is also allowed. That is MFA number 102085 of 2022. And the liability is fixed on the Forest Department. That is the respondent number 6. And the enhanced amount shall carry 6% interest, and there will be a regular order where all that you have to incorporate at the end of it. Next.
Much obliged.
Keep this in the file. Yes, next.
Sir, here for petitioner, respond number 3 has filed application for vacating stay. My lords, in this case, there are voluminous of documents which are in Kannada. I require some time.
What is this?
My lord, it
It
may
is-
not be needed, my lord. There's
If
an
that-
alternate remedy.
If in that
Order
case,
passed by the Deputy Director of Land Records, my lord, is appealable under section 136 of the Land Revenue Act before the Joint Director of Land Records.
Was on the my lord's judgment.
What is that?
In that
Alternative
case,
remedy
my
is
lords,
available under section. My lord's alternative remedy before the my lord's the JDLR.
in that event, my lords, in the parties have engaged the services of senior counsel.
My
My
lord,
lords, I request on 16th, my lords,
my lord, on
I'll
this
argue.
ground-
I am not avoiding the matter, my
This
lords.
ground, my
I'll
lord,
argue.
past 3 adjournments have
Illa,
happened
illa,
on
illa,
this ground only, my lord.
It was listed yesterday,
An
my lords, one
ex parte
submission.
interim
One
order.
submission.
1 minute. When there is an alternative remedy available to you, what
My
is
lords,
the senior counsel?
that is what we will convince your lordships, my lords, on that point also. My
Monday?
lords, some inconvenience on Monday for senior. 16th, my lords.
My lord, 16th, my lord, it is after the
No,
holiday.
16th is holiday.
My lords, 19th, my lords.
Unless this matter on 19th, no further adjournments will be granted on that day. Yes.
Please.
Lord, could it be taken up on 20th, my lord?
Yes, 20th.
Please.
One submission earlier matter. As per the direction of this honorable court, we have deposited the 50% of the amount, your lordship.
That will go. The amount in deposit shall be forthwith transferred to the trial court.
Because we have filed the.
You have deposit. So
release.
the amount in deposit, the appellant
Appellant.
KGID is at
Please.
liberty to withdraw the amount.
Please, your lordship.
Yes, next.
Number 10, adjourn. Seal number 11. Gita KM.
Claimant appeal for enhancement, your lordship. Case of injury, delay of 26 days.
Here Bajaj.
Bajaj
Who
Alliance.
appears for, who are the panel counsels?
RR Mane, SK Gayakmat.
Right, sir, one name, so and so is
Yes.
directed to take notice on behalf of the respondent number 2. The appellant shall serve the copy of the appeal on the counsel for the, on so and so. This is matter next week, that is on
Please.
13th.
Much obliged.
Yes.
Seal number 12.
Take that. Yes, next.
Seal number
Lord,
12.
I appear for the respondent in the 12th matter.
Girish Yadwat.
Sorry, I appear for the petitioner.
Respond number 9, my lord.
Please. Lord,
I have
What
filed-
is CC?
It's cash
This
certificate.
is a caste certificate matter, my lord.
CC is caste certificate.
Because all these abbreviations are new to me.
Yes. GMCC is caste certificate. Lord, the petitioner.
Let's look at your prayer first.
Yes.
So that I'll understand.
Yes, yes.
What is DCV?
Yes, ma'am. I'll just give that background in 2 sentences and then, my lords, if my lords permit me, I'll argue. I'm challenging the order
Before
of
that,
remand.
my lord, may I make a mention?
I'm for
Lord?
the-
Before that,
let
my
my
lord,
senior
my
my lord wait
submission
for 2
is.
seconds. I'll just give the gist of
No,
the
no, no,
matter.
no. I am not taking
Yes,
much
yes.
time. What I am referring, my lord, all annexures are in Kannada, majority of the annexures. If it is translated, it will be well and good, my lord. So that my lord can acquainted what contains in that order.
Before that, let me understand what.
If that
what
is required, certainly I shall do that.
Yes, yes.
I'll be
Please, my lord.
obliged more than my lord. What is challenged, my lord, is annexure K, which is an order passed by respondent number 2. My lord, setting aside the order passed by the District Caste Verification Committee.
See who are the respondents?
Yes, my lord. Respondent number 1 is the state.
1 minute.
2 is the Deputy Commissioner and President
Oh, DCBC
Yes,
means
ma'am.
District Caste Verification Committee.
Yes, ma'am.
Please, madam.
3 is the deputy director.
3 is
No,
the deputy
He is the
director.
one who has passed the order.
Respondent number 2 is the one who has passed the impugned order, my
No,
lords.
before that, he has set aside the
Before
order
that, deputy director, my lords.
What is the order of the deputy director?
Yes, my lord. Before the deputy director, the respondent number 9 had challenged, my lord, my caste certificate. My lord, he, after verification, said that, my lord, I belong.
Caste certificate is issued to you.
Yes, ma'am. Caste certificate is issued in the year 1976, 31/7/1976.
That was questioned before the third respondent.
That was questioned before, my lord,
Question.
no, that was questioned before, my lords, the District Caste Verification Committee.
Hmm.
This, his petition was filed, my lord, somewhere in the year 2019, my lords. The order of the District Caste Verification Committee filed, my lord, annexure G is dated 12/11/2019.
Is it the order of the second or the third
No,
respondent?
that is the, my lord, the order of the,
Third respondent.
yes, my lord.
Is on 12/11/2019.
I'm sorry, my lord. Second respondent. Second respondent is the
Second
chairman.
respondent.
Second, third, my lord, fourth and fifth respondents are a committee consisting of 4 members. They have passed
What was
this
the
order.
order dated 12/11/2019?
But there is some misunderstanding, it appears by me, my lords. The order which was challenged under annexure K, that order is, my lord, the order of the District Caste Verification Committee. That is at annexure G. That was questioned before the, my lord, Commissioner for Social Welfare.
Where is he,
Yes,
a
ma'am.
party?
It appears, my lord, that is what the mistake I have committed. The second respondent should have been, my lord, the Commissioner for Social Welfare.
Hmm.
He has not arranged as a party in this.
Yes, that appears to be a mistake on my part, my lords.
Let him amend the
original
my lord,
order-
the petition.
Order of the social director.
Commissioner for Social Welfare.
Commissioner Social Welfare is assigned before this court.
Ah, yes, my lords.
And he is not a party.
He, my lord, is
He is not a party.
He is
to
not
this
a party, ma'am.
petitioner. Which the petitioner shall file the, shall amend the cause title. Let's this matter next week. Yes, next.
In the meantime, my lord, your lordship can direct them to translated copy so that it will be easy for my lord to understand.
The orders, only orders you file in, file the transcript.
yes, ma'am, that I shall do. Only, my lord, I'll make one submission. I am challenging, my lord, the order of remand on 2 legal grounds.
But he should be a party.
You will argue on
No, that
merit.
I'll do. But, my lord, regarding translation, what happens is, my lord,
Translation is
entire material is in Kannada. So, my lord,
order.
orders I shall, my lords.
Only orders.
DCBC order, let him translate and file it before.
DCVC order and, my lord, the order in election. I shall do that.
The petitioner shall
Please,
file the translated copies of the orders passed by the Commissioner,
Noted.
Social Welfare Department, as well the District
Caste Verification Committee,
Caste Verification Committee.
annexure G. My lords, permit, my lord, I'll amend the cause title and implead, my lord, because it is the party represented by my learned senior. I'll implead and let him take notice for respondent number.
Yes,
I'll make him as respondent number 10, my lords. And
it can be.
I'll file an application.
Prayer also has to be amended.
Confusion, my lord, I'll file an application.
Yes.
Obliged, my lord.
Yes.
Case, my lords, I have filed.
Wherefore, my lords, petitioner, in this case, my lords, we have filed additional amended petition. Lords, for first and foremost, I require some time, my lords, for address the arguments on merits. And
Because you can't seek in every
illa,
matter.
not in every matter.
Petition,
My lords,
they'll be having
I
their
understand.
urgency.
And another thing, my lords, in this case, I challenge the validity of the provisions of Karnataka Gram Swaraj Act, for which, my lords, state has to respond, my lords. For validity, I have challenged provisions of that, for which state has to file objection.
Have you filed your objections? Who are you?
My lords, I appear for Jilla Panchayat, Taluk Panchayat and
Gram Panchayat.
For response number 2. And the
The
we have-
petition is filed questioning the virus of which provision?
Lords, section 199 of Karnataka Gram Swaraj and Panchayat Raj Act 1993, my lords, as amended by Act number 44 of 2015.
The writ petition is filed. questioning section 199(1) of the Karnataka Gram Swaraj and Panchayat Raj Act 1993 as amended by Act number 44 of 2015. An interim order was granted earlier. Now the vacate petition is filed. However, the government has not filed their objections. Let's just matter after 4 weeks by the time the government shall file their objections. Interim order earlier granted is extended till then.
Please.
This vote. Yes.
Bill number 14. English we Kattimane.
Appellant melody. Balupesi ready bill. 511 days melody delay melody. Old Act melody. Old Act melody.
Old Act.
Yes, melody.
Shall we continue?
I am for R3. Undertakes to appear R3.
No, about the delay. Delay.
511 days melody.
It may be condoned.
Huh?
It may be condoned in the old act.
1 of 2025 is filed to condone the delay of 511 days. This award is passed under the old act and no objections are filed with the respondent for the reason stated. The delay is condoned. Yes. What about this IA2?
Here 2 melody, stay melody, the execution operation melody. 50% deposit ready melody.
The land count, I number 2 of 25 is filed seeking stay of the so-and-so. There shall be stay on the condition that the petitioner, the appellant shall deposit 50% of the amount and the same shall be kept in the fixed deposit like there are usual orders in the other same policy.
Permitted to release after depositing the amount, permitted to release.
You're for the claimant?
R3.
Huh?
Claimant, Your Lordship.
Claimant, madam.
You're for the claimant?
Yes, ma'am.
Yes. The 50% of the amount the claimants are at liberty to withdraw.
Another matter is filed by the claimant is connected with this.
It has to be
Enhanced appeal.
list along with so-and-so. Yes, next.
Number 40.
Yes.
Bill number 15. Preeti Shashank.
Lordship,
Pakewadi.
in this case, stay was granted on 11th day of November, and I had
Already here.
Please.
So what is on
Now,
what?
I will file the deposit memo to show that we have complied with the stay order, my Lordship.
No, anyhow, like what on what ground you are before this court?
There is no permit to the vehicle, my Lordship. No permit at all.
The cover will apply.
The-
This is before amendment or after amendment?
Before amendment. After
cover will
amendment.
apply.
I apologize. After amendment. After amendment, my Lordship. My Lordship, his case, the appeal filed for enhancement of compensation,
Yes,
that is pending before division bench.
Division bench.
Please,
Then we'll tag this matter also to.
please.
It is submitted that the appeal filed with the claimant seeking enhancement is pending before the division bench. That is MFA number. Write on a paper and give.
That kept below, my Lordship.
Where do you get that?
College reflected in college.
Find the MFA number so-and-so, and registry is directed to list this matter before the revision bench along with so-and-so. Yes, next.
Bill number 16.
My lord, I am for the appellant in this case, my lord. This is an ex parte decree. Ex parte decree in insurance company. This is appealed by the insurance company. Ex parte decree has been passed. Then we filed a miscellaneous petition.
What we do is, you please argue the main appeal itself, then we
Yes,
will
ma'am.
condone the delay and.
Yes, ma'am. Yes, ma'am. The main contention is that is the policy is an act policy. There is no coverage for the pillion rider. There is no coverage.
My lords, for a moment, there is a delay of 4,644.
Ex parte order.
So he has to show that no notice was served to him. My lords, in his cross-examination, he has.
So please understand, it is a insurance company.
My lords, as-
When you are not legally entitled for something on
No,
these technical
but my lords,
grounds, we will not interfere.
new judgment of the apex court says, my lords, pay and recovery order is there.
All facts of the, depends on facts and
Please.
circumstances of each case.
Recently.
We can always differ.
Yeah,
Take
yes,
that.
yes, please.
But it is an act policy. When the pillion rider is not covered, for some
My
reason,
lords,
the
if
compensation
he
is
pays, my
granted.
lords, extra premium, then
There no extra premium is paid.
extra premium, if extra premium is
Let's
there,
see that.
ultimately, yes.
Let's
Lords,
see that.
he has to show that, my lords, whether it is a policy is a.
They are
for-
produced before the
He is
tribunal. madam.
directed to call for the TCF.
My lord,
This is
they have filed execution attachment. BLP is in the doorsteps of the insurance company.
On 12th of February, the appeal is filed with a delay of so and so. Land counsel for the appellant submits that it is an ex parte order. It is a case of the insurance company that it is an act policy and the pillion rider is not covered. Land counsel for the respondent submits that they have come before the court with an inordinate delay unless and until it is explained that they satisfy the court that there is the court that there are valid reasons and they have not received the notice. They are not entitled for any interim order. Considering the fact, considering the submission of the learned counsel for the appellant that it is an act policy and the pillion rider is not covered, they shall be stay on the condition of depositing 50% of the amount. Registry is directed to call for the TCR. This is matter on 18th of February. Yes.
Amount is to be deposited before tribunal, my lord.
Wherever you want to. Yes.
Lord, I am appearing for the appellant. This is yesterday's matter. My lord, the appeal by the corporation. This is a AC bus. My lord, he put, my lord, his hand in the right window, rear window. My lord, the complaint itself, my lord, shows that he put his hand, my lord, on the information issued by the brother of the, my lord, deceased, filed complaint after 5 days. He himself stated in the complaint that, my lord, he put his hand in the right side. At that time, my lord, the accident took place due to rash and negligent driving of the lorry. And my lord, the charge sheet has been filed, charge sheet not filed against the driver of the bus. Only, my lord, the investigation has been conducted by the police and they have filed the C report against the, my lord, the lorry not traced out, my lord. That's why, my lord, thereafter, my lord, this on that ground, my lord, he failed to prove the rash and negligent driving of the driver of the bus. The claim petition has been dismissed. Against that order, my lord, they preferred, my lord, the MFA for this honorable court. This honorable court, my lord, while remanding, consider the contributory negligence of the, my lord, the driver of the bus. My lord, the tribunal, my lord, relying the, my lord, the evidence of the claimant, entire negligence has been saddled upon the, my lord, the driver of the bus. Though, my lord, no charge sheet has been filed against the driver of the bus. My lord, at least, my lord, the deceased also, my lord, contributed to the, my lord, the accident.
Counsel for the appellant submits that there is a contributory negligence on the part of the deceased. The court, without considering the same, has fixed the liability on the driver of the bus and the driver of the bus. It is submitted that when it is in the complaint itself discloses that he has kept his right hand. He has kept the right hand.
Right hand, madam. To the
outside,
window, right window.
On the
side.
window outside. The court ought to have fixed the contributory negligence. The appellant, they shall be stay of all further proceedings on the condition that the appellant shall deposit 75% of the amount, compensation amount. And on such deposit, the respondents or the claimants are at liberty to withdraw as per the conditions laid down in the award.
Please.
Copies to the respondent. Yes,
My lords. My lords, I appear for the petitioners, my lords. Petitioner is plaintiff number 18, my lords. My lords, pardon me, my lords, there is one inconvenience, my lords. I am relying on the cross-examination, my lords. It is entirely in Kannada, my lords. I need to file a translation copy, that's it.
This is matter after 2 weeks.
My lords, it may be listed on Monday, my lords, because in the trial court, the matter is on Monday. And
this is matter on Monday. If look at it, interim order is there extent.
there is interim order, my lords.
Yes, next.
Obliged.
Number 19. 14%.
Appearing for respond number 2, my lord.
I appear for respond number 1, my lord.
I am the petitioner in this case.
Request, my lord, I will file an objection to the IS filed by the pertinent person. Request, my lord, take on 19th.
Who is for the petitioner?
I am the petitioner, madam.
Then what is your objection?
To the IS filed by the for
Yesterday I called and
sitting
informed
convenience, my lord. To I number 7 and 8. And to the memo for production of documents filed with the pertinent person. Even my incomplete documents have been given served, my lord. Complete documents have not been served.
Yesterday I called them and I sent a message also to receive, madam, but they are not receiving. Now it's ready with me, Alicia.
What is the writ petition? Please
Madam,
come to the writ petition.
my lord, Chaudhary Charan Singh University, Meerut, I have learnt LLB, madam, and they sent the genuineness of the certificate to KSBC, madam, on 22/4/22, and again.
Please come to your prayer.
Means,
Where is your prayer?
the complainant is not my client, madam, but he has placed the complaint before the disciplinary committee in number 83/24 to quash this.
Come to your writ petition. Where is the prayer in the writ petition? Let me understand the facts.
The complainant is telling that I am misusing the sanad issued by the KSBC, but he is not my client, madam.
The party.
Prayer ಏನಿದೆ ಅದು ಹೇಳಿ page number ಎಷ್ಟು?
Party, the writ petition is filed by party in person. List this matter before as.
Quash the complaint before the disciplinary committee of a KSBC.
Other bench, as a party in person is not comfortable arguing in English. Yes.
Your Lordship, may I request I appear for respondent number 1, my lord? Your Lordship, I request that the petitioner may serve the copy of the writ petition because it has not been served upon me, though I requested.
On the respondents, it's next 20.
Please.
Admission matter.
My lord, I appear for respondent.
Yes.
This is a petition for appointment of an arbitrator under section 11 of the Arbitration Act. Before I come to the arbitration clause, ladyship, if you can just brief.
For the respondent or the petitioner?
I'm for the petitioner, ladyship. Let me briefly outline the facts before I come to the arbitration clause.
My lord,
this is in respect of two work.
One submission, my lord. We have already sought the approval of the arbitrator. If that confirmation is agreed upon by the arbitrator, then we have no problem with going ahead and allowing the petition, my lord. Any date next week would be a good time.
Ladyship, I got strong objections. Matter was listed on 5th of December. They did not appear.
Why are you not coming to the court? Why you every day appear online?
My lord, only just today we have appeared online. Some inconvenience, my lord.
Is this matter on 19th of January, on the day the respondent shall appear, the counsel appear physically before the court, not virtually. We'll dispose it off on the day.
Ladyship, I'm coming all the way from Bombay. I'll be coming on 19th.
That day will not adjourn.
Yes, yes, that may be kindly be noted, ladyship. Yes, yes.
We have already sought the approval of
Yes,
the
exactly. That's the reason I'm taking the effort to come here.
Serial number 21.
Much obliged.
Yes, Vakul.
Your Lordship, I'm appearing for the claimant. It's appeal for enhancement, Your Lordship.
Yes, who appears for the respondent?
I appear for the respondent number 2, Lordship.
Yes.
And I have filed a wakalat in cause list. It is showing that we cannot file for respondent number 2.
Yes.
It may be removed, Lordship.
That we will, in the order I'll.
Please.
Yes, where is the table?
Your Lordship, I'm appearing for the claimant, Your Lordship.
There are two MBCs. Which MBC this is arising out of?
Your Lordship, both are connected, Your Lordship, 21.
There are two matters, yes.
Yes, Your Lordship.
So now, MBC number 102.
101,990 of 2020.
2019, against it, what is the MFA?
101,990, Lord.
101.
That is first appeal, Lordship.
990 of 2024. Then the second one is MBC 104. Then the second appeal.
Please, Lordship.
This is the second appeal, MFA 101,964. So first we'll see MBC 102. Where is the table in that?
Lordship.
Compensation, where is it?
Lordship will get in.
Page number 2, Your Lordship.
Page number?
2.
2.
Yes, Your Lordship.
It can't be 2.
Judgment.
Lower court.
Lordship 45, Lordship.
It is paragraph number 34 at page number, internal page 28. So it's a case of injury.
Yes, Your Lordships.
How many, what are the injuries sustained by the claimant?
Lordship, fracture of left tibia, Your Lordships.
One fracture.
Yes, Your Lordship.
So
Para 39, Your
under the
Lordships.
head of pain and suffering, we'll grant 40,000. Then medical expenses as it is.
Your Lordship. Lordship,
Please, Lordship.
they've taken the disability at 3%.
No, you come to page number 36,
Yes, your Lordships.
internal page 28 of the order.
Yes, your Lordship.
You find a table there?
Yes, your Lordship.
So we will go as per the, yes. So pain and suffering will grant for one fracture 40,000.
Yes, your
Then
Lordship.
medical expenses as it is? Or you are contesting on that? Medical expenses?
Medical expenses.
As it is produced bills, Lordship. They have produced the bills and same is exhibited.
There can't be any dispute on medical expenses. So
Your Lordships.
33,900. Then how many days he was in hospital?
4 days, Lordship. 4 days. From 2/11/2018 to 5/11/2018.
Already whatever is the amount that is granted is on the higher side, we will not interfere with that. Then coming to the loss of income during later period. Which year is the accident?
2018, Lordship.
And is there any independent evidence with regard to the income?
No, Lordship.
No, your
So
Lordship.
it is 11,750.
Same is
So
taken by the tribunal.
11,750 into 3.
1,41,000.
1 minute. It comes to 35,250. Then loss of future income. What is the evidence of the doctor?
Hamali, Lordship.
Hamali.
Evidence of the doctor. Please come to the loss of future income.
He is not a treated doctor, Lordship.
I think, first of all, in this case, MBC 104 is first, so it is 104. Yes. So, please come to that paragraph. Where is this future loss of income you discussed? The accident?
Lordship, that is para 21.
Yes.
Lacerated wound and
No, the court had taken 3%. Where is the evidence of the doctor? Here it is. It's at paragraph 29. Read that, paragraph 29.
Lordship.
PW3 Dr. Ramakrishna, who was issued disability certificate as per Exhibit P34, has opened the petitioner due to the injury sustained as to bear permanent partial disability of 25.4% to the whole body. Though PW3 has assessed the physical disability at 25.4%, the same is not rational and the same cannot be equated with the percentage of loss of future income earning capacity of the petitioner as held in the case of Rajkumar versus Ajay Kumar and another, reported in 2011 1 SEC 343, wherein the Honorable Supreme Court has laid down the principles of assessment, particularly in determining the loss of future earnings of injured with reference to the is permanent disability. Certain illustrations have been given by the Honorable Supreme Court regarding factors to be considered while determining compensation under the head of loss of future earnings. The principle in the said decision have been summarized by the Honorable Supreme Court at para 19 of its judgment as follows. We may now summarize the principle.
How can there be a disability of 28%? Court has rightly taken.
Actually, 1/3 should be taken. Out of 25, 1/3 should be taken.
No, he says 28% is to the whole body, not to the limb.
Yes, Your Lordship.
So that assessment itself is bad and nothing has been produced. And the court says the X-ray it doesn't show any fractures.
Yes,
What was the income taken?
11,750, Your Lordship. 11,750.
So so it's rightly taken.
At least 1/3 of 25% shall be. 1/3 of 25% shall be taken, Your Lordships, for disability.
TCR is there?
TCR.
Is there? You have the evidence of the doctor? Please pass on.
Doctor evidence idru kodi. Doctor evidence. Pass.
You have, take that.
Aite. Doctor evidence flag haki.
I think the evidence of the doctor is not discussed. There is a elaborately has stated.
Elaborately in both the MVC.
That whatever the disability has stated that we will
3%
take
it is.
1/3 of it. We'll take 1/3 of it.
Yes, Your
The
Lordship.
lacerated wound and there is no functional disability, Lordship.
No, the court has not at all discussed what is the doctor like. He has in detail he has given the evaluation. The court has not considered.
But he is not a treated doctor and accident has taken.
Necessary. Doctor need not be a treated doctor.
Please, Lordship, I will leave it to the
What we
Lordship.
do is in 27.3% I think he has stated, we will
Please,
take
Lordship.
1/3 of it.
Please, Lordship.
Yes.
But X-rays and all they have produced, Lordship.
Because it is yes, a comprehensive evaluation of the disability. Why the court has not discussed, we don't know.
Para 44, my lords will get, Lordship.
Common physical to this whole, I have issued physical disability certificate. I see my certificate.
Internal page of 35, Lordship. Of the judgment.
So it is 25.2. So we'll take 25. It comes to 8%. We'll take 8%.
5 it may be taken, Lordship.
Lordship, 8 may be
Corporation.
taken. Your
So,
Lordship.
3 they have taken and 8 it will come 5.
11,750 into 12. What is the multiplier?
16, Lordship.
16 into 8 by 100.
Lordship, 102, 55 years age.
What is his age?
55, Lordship.
So then it is not 16.
I confused with the other one.
55
33
years. It is 11. 11.
11.
It's coming to 1,24,080. So it's coming to 2,53,230 against 1,68,652. Now we'll go to MBC 102. The
104.
table is at 37. Come to 37. How many are the injuries? What are the injuries?
Lordship, in 102, it's the fracture of left tibia, Lordship. 102, it's fracture of left
Where
tibia.
do you get it? Please come to the discussion.
Para
25,
39,
Lordships.
Para 39 of the judgment. Page number
Para 35.
39, Lordships.
39. Yes. Petitioners produce exhibit P36. No, we'll go, we have to see the injuries. Where is the wound certificate? Petitioner has sustained, taken treatment and so and so. He had sustained tenderness over the left shoulder,
Yes.
abrasion over the left forearm,
Simple
lacerated
injuries.
wound over the knee joint.
Simple injuries in nature, Lordship.
38. It's 102. 104, I think.
I think the record which you have placed before the court is pertaining to the doctor evidences MVC 102, not 104.
My Lordships.
25.2 is pertaining to 104, 102.
Para 25, my lords will get it, Lordship. Para 25, Lordship.
1 minute.
Of 104.
1 minute, 1 minute.
Madam, 102 ಮುಗ್ದತಿ. 104 ಮುಗ್ದತಿ, 104. ಇದು 103.
Yes.
ಇಲ್ಲ ಮೊದಲು 104 ಮುಗಿಸಿದ್ರಲ್ಲ ಈಗ 104.
Yes, Your
The
Lordship.
3% is correct in 104. What I have read is 102. That's evidence of the doctor is very clear in 104, that MVC number 102, 104. We will take the disability as it is. In this, we will take 8%.
My lords, in 104.
104.
In 104, para number 25 may be kindly seen, my lords.
I'm looking at the
Wherein,
evidence of the doctor.
Please, my lords.
I'm looking at the evidence of the doctor in 104. Now, what I read earlier and considered it as 8% is in MVC number 102. 104, what is the finding of the court is what reflects in the evidence also.
Same, both are same.
So then what we'll do is in MVC 104, we will take the loss of future income as it is. 94,752. It's coming to 2,23,902. Yes, now let's go to the next MVC, MVC 102.
104.
Petition is taken. Pain and suffering in this will grant 40,000. How many days he was in hospital?
Same lordship, from 2/11/2018 to 5/11/2018.
Only 4 days in this also.
Please lordship.
So incidental expenses as considered by the court will not, because there is no appeal of yours, 10,000. Medical expenses as it is 23,400. Loss of future income is concerned. Here we'll take 8%.
Please lordship.
So, same income is as it is 11,750. 11,750 into 12. Into what is the multiplier?
It's 16 will come lordship. Age is 33.
16. Are you sure?
Sure lordship. MUC 104. Age is 33.
It's not MBC 104.
Your lordship,
lords,
multiple
104.
11, your lordships.
104, my lordship is considering 104 MUC.
First we have considered 104. Now we are considering 102.
102 means lordship 55. Multiplier is 11 lordship.
Then that will make the difference. It is 11,750 into 12 into, no, in this what we did is, as it is, whatever the trial court has taken, that I have confirmed. So that calculation is not an issue. So that now it is an MBC 102. So 11,750 into 12 into 11 into 8 by 100. One lakh 24,080. Then loss of income during laid up period. 11,750 into 3. 35,250. Loss of amenities, 20,000. Legal expenses, 10,000. It's coming to 2,62,730 against 1,14,600. Please come. What's your name?
Respond number 2, Vaishali Kalaki.
Your name is?
It has shown lordship, but VK not filed. I have filed Vakalat in the month of September 2024.
Vaishali Kalaki. Agreed with the award passed in MVC number 104 of 2019 and MVC number 102 of 2019 dated 21st February 2024. The claimants are before this court seeking enhancement of the compensation. As the court below had disposed of the appeals by way of a common order, this court is also disposing of the matters by way of a common order. So, side head. MFA 101964 arising out of MVC number 104 of 2019. The tribunal has granted the compensation as per the table given below. That is at paragraph number 34, extracted. Learned counsel appearing for the claimant submits that when the claimant had sustained the injuries, the court had granted only 20,000 as under the head of pain and suffering. No amount is granted under the head of loss of income during the later period. Further, for the loss of amenities and attendant charges altogether, an amount of rupees 10,000 is granted, which is on the lower side. Further, it is submitted that the court had failed to consider the evidence of the doctor and had failed to take into consideration the disability. It is further submitted that no amount is granted under the head of loss of income during the later period. Next parallel, and counsel appearing for the insurance company submits that the court had rightly.
Corporation, Lordship. It is corporation.
Huh?
It is a corporation.
And counsel appearing for the corporation submits that the court had rightly granted the compensation and there are no grounds to interfere. Next para. Having further counsels on either side, peruse material on record. Considering the injuries that are sustained by the claimant under the head of pain and suffering, this court is granting 40,000. Medical expenses as it is. Incidental expenses, the court has rightly considered and granted 10,000. Then coming to the loss of income during the later period, 11,750 into 3, 35,250. Loss of future income, the court had rightly granted and this court finds no reasons to interfere. Under the head of loss of amenities, this court is granting an amount of rupees 10,000. In the light of the law later on in make allowances so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 2,33,900. The enhanced amount shall carry 6% interest. Then MBC 102. MFA number, you just verify also, MFA number 101,990 of 2024, arising out of MBC number 102 of 2019. The tribunal has granted the compensation as per the table given at paragraph number 48. Learned counsel appearing for the claimant substance that the tribunal had, when the doctor has given the evidence that the disability that is sustained is 25.2. The court had taken 3% as disability, which is on the lower side. It is submitted that the court ought to have considered the evidence in its perspective and ought to have granted the compensation. And even under all other heads also, the compensation that is granted is not just unreasonable. Next, learned counsel appearing for the respondent insurance corporation submits that the just and reasonable compensation. There are no grounds. Next, having got so and so. The claimant has sustained a fracture injury and other simple injuries under the head of pain and suffering. This court is granting 40,000. Incidental expenses 10,000. Medical expenses as it is. Coming to the loss of future income, this court has perused evidence of the doctor. According to him, he has sustained 25.2% disability, and he has in detail has stated what is the disability sustained by him. Considering it as a limb disability, 1/3 of it would come to 8%. Hence, under the head of loss of future income, 11,750 into 12 into 11 into 8 by 100 is 1,24,080. Under the head of loss of income during the later period, 11,750 into 3, 35,250. Considering the disability of 8%, loss of amenities, this court is granting 20,000. In the light of the law laid down in Mekala so 10,000. Altogether, the claimant is entitled for an amount of rupees 2,63,730. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 1,40,600 to 2,62,730.
Hello, Your Lordships.
Your Lordships, in 104, Your Lordships, income during later period.
Huh?
Income during later period is not granted.
What is that?
Income during later period, Your Lordships.
Income
Income during later period.
is granted in both the cases.
Much.
Yes. Still number 22.
Claimant appeal seeking
Ajnayam?
enhancement of compensation as well as legality of the judgment. Enhancement of compensation and the liabilities settled on
Who appears
the
for IFCO Tokyo?
MY Kati, my lord.
Mr. M.Y. Katti is directed to take notice on behalf of R2, learned counsel for the appellant, shall serve the copy of the appeal memo on the council. List this matter on 19 January.
Please, ma'am.
Yes. Yes, 24. 24.
My lord, claimant's appeal seeking
Ajnayam?
enhancement of compensation. I seeking dispensation in first case, my lord.
Of notice to whom?
R2 Tata AG, my lord. Claim petition is dismissed. Notice has to go to the R1, my lord.
IA 1025 is filed seeking dispensation of notice to R2.
Dispensation with regard to production of judgment and award, my lord.
Why?
The same is produced in the connected case.
IA number 1025 is filed seeking dispensation of filing of the certified copy of the judgment and award, as the same is filed in MFA number 100619 of 2025. Accordingly, IA number 102025 is allowed. The petitioner is permitted to take out notice. Who appears for IFCO Tokyo?
Tata AG, my lord.
Tata AG, who
Tata
appears?
AG, my lord. SK Kayakmat.
So and so is directed to take notice on behalf of the respondent insurance company, notice to the other respondents.
Please, ma'am.
Yes, give her right and give it. Yes, next.
Please.
Serial number 25 adjourned, serial number 26. Preliminary hearing matter. G.N. Raichur. G.N. Raichur.
Let's this matter in the month of March. Yes, next.
Writ of mandamus, my lords. Writ of mandamus seeking reimbursement, my lord. GST matter.
27.
Please, my lord.
Yes.
GST matter, my lord.
I am for the petitioner, my lord. I am for the petitioner in 26, my lord.
26.
26. I am for the petitioner, my lord.
Yes.
My lord, connection, some problem was there. My lord, what has happened in this case? It is a writ petition filed challenging the order condoning the delay, because this MBC petition is filed after the amendment, and in 166(3) 6 months time is given. After 6 months, no petition will be
I
maintainable.
think he's appearing in 25. I think he's arguing 25.
26, my lord.
26. 26 is a AC matter.
No, my lord. 26 is the writ petition. 26 WP 100929, my lord.
Huh?
Accident.
How will? Oh, that is against an interlocutory order. What is this? The petition of this government from police.
Sir, WP matter.
Quash the
WP,
improved order passed
matter.
interim
WP.
application under section 5 of the Limitation Act.
Yes. Now the matter is
Why the delay is condoned?
before the Supreme Court.
Delay is condoned.
Delay is condoned, therefore I filed a writ petition. Now the matter is before the
So
Supreme Court.
now the accident had taken place after the amendment.
After the amendment.
And the
Policy is there, man. That is no, we are not questioning the policy. We are questioning the
No,
maintainability.
policy is after the amendment or before the amendment?
Policy is before the amendment, my lord. But this point is before the Honorable Supreme Court
If
now.
it is, let's see, let us see the act.
166(3), my lord. 166(3). 166(3). No petition is maintainable.
1 minute.
No application for
Partly allowed.
No, I see somewhere I read the provision says about the policy also. If says the policy is prior to the amendment, then the amendment will not apply to that accident.
But no, my lord. There is no such provision which I gone through, my lord.
That's what, somewhere.
Now the matter is before the Honorable Supreme Court. Supreme Court has to pronounce this, whether delay can be condoned. Supreme
No,
Court
that
has
is
to.
another aspect. What I am saying is, if
I
the
understood,
policy
madam.
is
Policy
prior to
issue.
the accident, then they are governed by the unamended act.
But policy is also issued on 29/6/2022 as per the annexure A.
29?
29/6/2022 after 1/4/22. 29/6/2022.
That is what I asked you first, whether it is prior to the amendment or
right.
after the amendment.
Policy
Please
is
come.
issued after amendment only.
Agreed with the order passed in. Passed in MBC number 263, in I number 5, in MBC number 263 of 2023, dated 19/10/2024. What are you doing from the date of order till now? Your stay petition is not heard.
Not heard, my lord. Adjourned. It was adjourned, my lord.
No, an order that is passed in the year 2020. What is it?
Order passed on.
Then we will order notice. I will not stay this. You have been waiting. Notice to the respondent.
Number 27.
But the petitioner is seeking a writ of mandamus. Petitioner had undertaken several civil contracts and GST.
Like yesterday's matter.
Yesterday, similar
Yes,
matter.
what are your instructions?
Mandamus may be issued and authorities will consider their my lord's applications.
4 weeks?
4 weeks.
But they have
8
to
weeks.
reimburse the amount. They have to pay the amount.
No,
Yes.
your
Question of
representation
reimbursement,
will-
yes, they will decide, my lords, 8 weeks time.
Is filed. Seeking the following prayer. Extract the prayer. It is a case of the petitioner that he is a registered, petitioner is a registered civil contractor and also a forest contractor. He has been undertaking the civil work contracts awarded with PWD for the last several years. It is stated that up to July 2017, VAT was applicable for the works contract, and from 1/7/2017, GST was introduced and made applicable. As per the GST Act, the service recipient has to pay the GST at the prescribed rate to the service provider. After the GST was introduced on 1/7/2017, 12% GST was payable on work contracts. From 18/7/22, the rate of GST has been increased to 18% even for the garment works. It is a case of the petitioner that the respondent awarded the civil work contract. The respondents have awarded the contract to the petitioner after 1/7/2017 relating to construction of Mandir at Mughal Court and Islur Panchayat, and also construction of, what is that, Carland near Hital Makki in Kumta by the respondent number 1. And it is also stated about the kind of works that are allotted to the petitioner. It is a contention that the respondents are required to pay the GST amount to the petitioner. As they have failed to reimburse the GST amount, the petition has made representations to the respondents stated 19/8/2024 and 15/3/2025, that is to respondent numbers 1 to 7, to pay the GST to the petitioner. It is a grievance of the petitioner that, in spite of the repeated representations given to the respondent, they have failed to consider the same. Learned AGA submits that they will, which respondent has to consider?
My lord,
all
annexure A is to be considered by respondent number 1. So there are up to
So
annexure
respondent 1 to
7.
all of them have to consider.
Annexure A is to be considered by respondent number 1, annexure B by respondent number 2, annexure C by respondent number 3.
The learned counsel appearing for the learned AGA submits that the petitioner's representations to respondents 1 to
7.
7
will be considered in accordance with law. Next para, having heard so and so. The petitioner has given a representation to respondents 1 to 7. 1 to 7. The respondents are duty bound to consider the representations in accordance with law. And considering the submission of the learned AGA, this court deems it appropriate to pass the following order. The writ petition is disposed of, directing the respondents 1 to 7 to consider the representations dated 19/8/2024 and 15/3/2025. No, there are so many. 19/8/2024, 15/3/2025. So only 2 dates.
2 dates.
15/3/2025.
My lord,
Considered by respondents 1 to 7 as expeditiously as possible, but not later than 4 weeks.
my lord, they should also consider the order that is passed in WP number 10490, wherein a specific direction was given to reimburse the amount. My lord. I have produced that
In
annexure.
light of these contentions, it is submitted that the petition has already filed WP number
10490/2023.
10490
Not the petitioner, my lord. Similar applicants where
it is submitted that in that writ petition, when a similar issue fell for consideration, in that writ petition, court has directed the respondents to return the GST amount.
pay the GST amount.
Pay the GST amount.
It's 8 weeks time.
Huh?
8 weeks. 8 weeks time may be granted.
Please.
I take notice for R1 to R7.
AGA takes notice for respondents 1 to 7.
Yes.
My lord, there are similar other 7 matters. May I give the list, my lord,
Yes.
so that it can.
Take that. Yes, next.
I appear for the petitioner, my lords.
Yes.
I appear for the petitioner, my lords. The petitioner has challenged the Lok Adalat decree, my lords. The petitioner had filed the suit for partition and separate possession. During the pendency, my lords, the matter was settled. And when the decree was sought to be acted, my lords, the petitioner comes to know that the material fact has been suppressed, my lords. And
Nor the plaintiff.
I was the plaintiff, my lord.
Then who suppressed the material facts?
For the reason, my lord, I had claimed 1/5 share.
Come to the award.
All the properties that are mentioned in the
Come to the award. Where is it?
at annexure F, my lords.
Page number?
58. It starts, order, I have produced the order sheet
Yes. Let's read.
at page 60, my lord. Yes. So that is the IA, heard counsel for plaintiffs on IA number 1 filed under order 39 rule 1 and 2 CPC seeking to restrain defend 7 and his agents or anybody acting under him from alienating the
No,
suit.
it's not about this. Where is the Lok Adalat award? I'm asking.
About, I know. At page 62, my lord.
Page 62.
It's recorded in the order sheet, my lord. May I read? My lords, may kindly see annexure A.
Where is your terms of compromise?
Please, please. At page 21, at annexure A, my lord. Now, what has happened, my lord, in the terms
No,
of...
let's see. First of all, you're the plaintiff.
Please.
And you have your eyes wide open. You have entered into a compromise. Now you cannot say that somebody has, something is wrong with the compromise. Let us read. Where is that, the compromise memo entered into between the parties?
Please, my lord. My lords, may kindly see...
What is the date of this compromise?
15/3/2024, my lord.
15/3/2024. Let's see.
May I take your lordship's kind attention to serial number 1 of the terms of the compromise, my lord?
At page number?
23.
Yes.
Yeah, my lords. Plaintiff number 1 by name Gangava Siddhappa, who is the mother of the petitioner, my lord. She has given up her rights, title, interest over her share in the suit properties in favor of plaintiff number 2 and defend number 2.
You are plaintiff number 2?
I'm plaintiff, I'm son, my lords. And other respondents are my brothers, my lord. Now, at serial number 2, that is the petitioner, my lord, petitioner number 2. So to my share, Maruti Siddhappa Gadivada, which are situated at Kargaon, Dharwad village and Hukeri town, to which, to my extent, my lords, it's at serial number 1, 2, 3, 4, 5, and a check of rupees 57 lakh was given to me, my lord.
Yes.
Thereafter, my lords, at serial number 3 of the joint memo,
yes,
Vittal Bhimappa Gadivaddar and defend number 3 by name Shri Pramod Bhimappa Gadivaddar. He is the son of the first respondent. Both are sons of the first respondent. Since first respondent is deceased, my lord, this was the share allotted to them. Thereafter, my lords, now serial number 4, my lords.
To you, what is the fraud played by them?
My lords, may kindly see serial number 4. Now, the respond number 7 has, most of the shares has been allotted to his share, my lord.
What were you doing when you entered into a compromise?
My lord, petitioner number 1 is a very age-old woman.
You are petition number 2. Plaintiff number 2.
I'm appearing for both, my lords. Petitioner number 1.
That we cannot consider.
Allah, no, my lord, what has happened?
This is
Durgamma
the
stone
Lok Adalat awards have to be, the compromise has to be interfered with the court, then there is no finality to the litigation.
My lord, all are joint family properties.
The question is, forget about your mother. You're also there. You're plaintiff number 2. Everything, whatever is the compromise, it's not the case that there is fraud is played on it. Unless and until, only on those specified grounds, the award can be interfered.
My lord,
your lack of understanding and all can't be the grounds. Let us see the grounds that are raised by you. We'll understand what it is.
My lords, for a moment, serial number 4 at joint compromise memo, my lord.
No, come to your grounds.
Yes, please, my lord.
13, you say, respondent number 7 and 9 willfully and deliberately violated the Lok Adalat decree. So if they violated the Lok Adalat decree, you have an execution.
Please.
Next 4. As per their convenience. If they have done it as per their convenience, what are you doing? The further, as per the said compromise decree, respondent under 7 to 9 have not provided any share benefit from the Durgamma stone crusher. That is not the reason for the court to revisit the compromise. Next 16. Yes. So it's virtually you want to reopen that only for the reason that something else you want, and on that ground it cannot
My
be.
lord, I have issued the legal notice immediately when the decree was supposed to be executed. I issued the legal notice, my lord, that they have suppressed.
Knowing the
at
contents of the compromise memo, you have signed it, you have accepted it, and as you know, as per the settled law, you can't on these grounds. The court cannot interfere.
He's a very powerful person, my lords. In fact,
We can't. There is no sanctity for a compromise decree in this manner if we start
my
interfering.
lord, I have to that effect. I have also issued the legal notice, and there was no delay caused by my end.
No, just tell the court. Is it let us say there is some injustice to you. Is it a ground to set aside the compromise decree? The limited grounds on which a compromise decree can be set aside is on the ground of fraud, coercion, on
Fraud
other
and
grounds.
material of
No,
suppression
there
of
is
material.
nothing here. You say I should have been given that. If you should have been given some share, why did you sign it?
Petitioner
Nobody
number
compelled you.
1 is illiterate, my lord. Petitioner number 1 is illiterate. I have produced the Aadhaar card.
2 was there. 2 was there. Please come. The mistake you have committed is your client that he engaged. The writ petition is filed by 2. It's not alone the first. Second is the person who is educated.
In fact, even I am second counsel on record, my lord. I have recently filed my wakalat.
The present writ petition is filed, seeking the following prayer. The petitioners or the plaintiffs in the suit, that is OS number 375 of 2023, which is filed seeking the relief of partition. Then the parties have entered into a compromise, and basing on the compromise entered between the parties, the court had recorded the compromise, and the compromise decree in the Lok Adalat, a compromise was recorded, and an award was passed. Dated 15/3/2024. Now the present writ petition is filed, seeking to set aside the said compromise decree. The grounds that are stated and as submitted by the learned counsel for setting aside the compromise decree are that the 7 to 9, the respondent number 7 to 9 willfully and deliberately
My lord,
violated the law.
submission. I may be granted liberty to file fresh petition.
And willfully violated the Lok Adalat decree dated 15/3/2024 invoice number 375/2023. Further, the compromise is entered as per the convenience of the respondents number 7 to 9, numbers 2, 3, 7 and 10. It is also the ground that as per the compromise decree, respondent number 7 to 9 have not provided any share benefit from Sri Durgamma stone crusher and in the landed properties more fully summarized in the compromise petition. It is also stated that the petitioner requested respondent number 7 to 9 time and again to provide their share and to allot share in the landed properties. But they have procrastinated the matter on flimsy reasons. Since 5 years, they have gained the profit from the said Durgamma stone crusher and earned nearly 25 to 30 crores without providing any legitimate share to other plaintiffs and defendants, as well to the petitioners. Respondents 7 to 9 have suppressed all these material facts before the court. The respondent number 7, the undivided Hindu joint family properties were mutated or transferred. The properties in the name of respondent number 8 to 9, and the same is highly illegal and not sustainable. It is the case that they have got equal share, and as in view of all the suppression of material facts, the compromise decree has to be set aside. Land Council submits that the first petitioner is an illiterate. As such, she is not aware of the, as such, she has entered into the compromise, and on that ground, the compromise needs to be set aside. It is stated that immediately after the compromise, a notice is given to the respondents. Next paragraph. Having heard the Land Council, the petitioner peruse the material on record. A Lok Adalat award public the compromise decree can be set aside only when there is a fraud or coercion and other on only the limited grounds. The grounds that are urged before this court are not the grounds on which a compromise decree can be set aside. The first petition, the plaintiff number 1 and 2 are before the court. 1 is the mother, 2 is the son. According to the counsel for the petitioner, she is an old person and uneducated. It is not the case that plaintiff number 2 is uneducated. Even apart from that, all the grounds that are stated that in one stone crusher, they are entitled for share. If that is so, what they were doing at the time of compromise? Why did they accept the compromise? And why did they sign the compromise memo? Nothing is forthcoming. On these kind of grounds, on an afterthought, the court cannot set aside a compromised decree. If in this manner, if the court starts interfering with the compromise decrees, then there is no sanctity to the same and there is no end to the litigation. In that view of the matter, this court do not find any reasons to set aside the compromise decree dated so and so, accordingly dismissed.
29, I have a party.
Yes.
General parole awards.
Parole.
Parole
Similar
awards.
matters are listed on Monday, my lords. This
Monday?
is for general parole.
In this case, what is the reason?
In
This
this
is
case
for
also,
agriculture
lords,
purpose.
Huh?
for
Agriculture
agriculture
purpose.
purpose, lordship. From 12 years in prison, lordship.
Petitioner family occupation is agriculture. Petitioner is growing paddy crops and other crops in their agriculture land. Now it is a harvesting season.
As per the
The presence of the convict is necessary to harvest the crop.
as per the manual, it is provided, lordship. Law itself is provided, lordship. As per Karnataka prison manual, lordship. There are some which are for which
What I'm able to understand is for offences under 302, and on these grounds, the parole is granted.
that objective clearly drafted, lordship, in the Karnataka manual, lordship. Why the parole is necessary, lordship?
No, every year they
No,
can
no,
come
only
out.
two
like
conditions are there, lordship. For the granting the parole, lordship, only two conditions are there, lordship. Who is convicted, he has to must serve the 1/2 the sentence, lordship, or 2 years, whichever is less, lordship.
What is that?
1/2 of the sentence, lordship, or 2 years, lordship, whichever is less, lordship. He is eligible for parole, lordship.
Parole for now, for example, now the court will grant parole.
Please, lordship.
Again, when are you entitled for the next parole?
Please, lordship. Oh, only after the 6 month lordship. He is entitled for, he cannot file the next parole between the 6 month lordship.
So every 1 year he is entitled for parole.
Is entered. The manual says.
Manual say lordship. Manual is say the intention of the manual lordship to modify, to change his mind lordship. Only directly if he is released after the conviction lordship, he cannot be adjusted to the society as well as the family lordship. That is clearly the goal of the parole lordship. That is now produced lordship. Parole chapter 34. Clearly stated why the parole is necessary. Object of the parole lordship.
No, I do understand parole on some reasons like daughter's marriage.
Yes,
Somebody
there must be
ill,
some reason for that.
Not, he is not, the convict himself is unwell. I can understand. For harvesting the crop, for constructing the house, for that parole, that too in a 302 matters.
That is their lordship. That is the fifth one is their lordship. For harvesting as well as construction of the repair home lordship. That object of the parole lordship.
Now, in this case, he has been convicted under section 376D.
376.
Yes. And also 366 and 506 of the IPC.
To reach this goal lordship.
People go back again.
They will come back lordship.
Monday I will answer.
No, I'm asking you.
Yes.
Is he granted parole earlier also in this case?
In this case, it
In
is
this case, the first time lordship.
first time asking.
The same setup of lordship is granted a parole lordship. For harvesting purpose itself only lordship. Kindly pass, permit to pass on this. That.
General and emergency parole cannot be claimed as a matter of right, but it is a concession granted to the convicted prisoner. No, right from the beginning, it is the High Court who is granting the parole, or any change in the law?
Usually, Milord's authority has to grant. In case they reject, High Court is.
Oh, like right from the beginning, it's a High Court who grants it.
Yes.
You striked off something? General
That is amended lordship 2022. That's why I will strike out lordship. That's available in soft copy lordship. That not hard copy is not available. That's why I will strike out lordship.
This case is not eligible because the sentence imposed, kindly see annexure A, my lords. Total sentence, life imprisonment, the remainder of his natural life.
Reminder?
His natural life.
Oh.
Yes. That is not entitled for any parole because any concession given by way of my lord's parole will not be will not be exempted in other cases.
Then what about these rules in respect of general parole? What has to be followed? It says who desires to be received so and so submit his application. After receiving the parole application,
yes,
the concerned superintendent of prison shall obtain report from Commissioner of Police.
Yes.
Then you have to place all this before the court.
As they usually reject on the ground that my lords, they are not entitled since they have committed an heinous offense.
No, but your rule says
Yes.
it is not referring to heinous offense. Even it is a heinous offense also they are entitled.
Yes.
That's what it says.
Yes. It's kindly out on Monday. I will go through the lords.
I think there needs to be some assistance from you on this.
Yes, yes.
It is, I feel it is somewhat very strange.
Yes.
Then everybody who is convicted for these kind of heinous offences,
yes,
so happily every 6 months you come out, you be here for 3 months, again you go. After 6 months you come, then what is the sanctity
yes,
of keeping him in the prison for the offence, a heinous offence he has committed? 376D. What is the law on this also? Please tell the court.
Please.
The following persons, categories of persons shall not be eligible for release on emergency parole.
That is emergency for only 15 days, Lordship.
Prisoners convicted,
Only 15 days for emergency parole, Lordship.
Hmm.
The general parole, Lordship, ordinary parole.
So what's the difference between the two?
Emergency parole is only 15 days, Lordship. That is a different category.
A person who is not entitled for 15 days parole is entitled for 90 days parole.
No, emergency parole is the authority of the grant, Lordship, only for 15 days, for emergency, for death, for 10th function.
But now they have classified certain people are not entitled.
Please, Lordship.
Prisoners convicted for the offense such as dacoity, terrorism, kidnapping, smuggling, NDPS Act and the Foreigners Act, serious prison violence, assault, outbreak. So 302 will not come under this. 376 will not come under this. No, he says, if he was convicted for offences mentioned in chapter 6, 7 and 14,
Yes,
they are not entitled.
they are not entitled.
That's what it says. See, however, any convict prisoner under category of non-eligibility of emergency parole mentioned under this rule shall be eligible for emergency parole only on the grounds of death of his or her grandfather, grandmother, father, mother, spouse, own son, daughter, grandson, granddaughter, brother, sister.
Yes, that is for only.
What I have seen.
Yes, emergency parole only, that is, my lords, not for general parole, that is applicable.
Please place before the court what is the law in this regard
Yes.
by the Honorable Apex
Kindly
Court.
have it. Next week, my lords, I will elaborate later.
We'll take up all these matters, not next week.
Yes.
We'll have it on 20th of January.
Yes.
Yes.
Case number 30. Anirudh K. Kulkarni.
Yes. No representation. Let's just matter number of marks. Yes, 31.
Case number 31.
Same. 32.
31. Cell number 32.
Lord, I am
Mrs.
appearing
Jnanaya
for
Swami.
serial number 31 and 32 together, my lord. I am appearing for the 31 and 32, my lord. That is a generic and Janaushadhi Kendra established in the government hospital.
30.
31, yeah. My lord, 31 and 32.
You don't appear in 30.
No, no, yeah.
Anirudh
Name is one and the same.
Anirudh.
Anirudh K. Kulkarni.
Yes, my lord. 30 and 31.
What do you want? You are arguing or you want adjournment?
No, my lord, the notice has to be given to the respondent number 1 to 4 through AIG.
Notice to the respondent. Who are respondents 1 to 4?
Please.
Respondent 1 to 5, my lord, AAG.
I take
And
all these
6.
for my lords.
He already is there.
1 to 4, no, for fresh time, fresh matters.
What is this GAST?
It is copy served on.
Yes. The again.
Yes, again, order has to be.
The respondent 1 to 4, AG is directed to take notice.
And
what are your instructions?
My lords, this is a case of Janaushadhi.
Huh?
My lords, the generic medicine case, my lords. This is a contract between the, my lords, the government and the, my lords, the petitioners. Now the.
Let us see the prayer. Please come.
Please.
To
My lord, in similar matter, it has been allowed, my lord.
1 minute. Further operation implementation the impugned government order bearing number dated issued by respondent number 1. Not to take any coercive action including closure, selling or eviction petitioners. Jan Aushadhi Kendra. Give that order.
Yes.
Maintain status quo as existing also regarding the operation of the government hospital. Give that.
That's the generic medicine, my lords, stores have been established in the premises of the, my lords, the hospitals.
Have you seen this?
Yes,
judgment?
I have seen, my lords.
It is,
It is covered, my
covered
lords.
by this
Yes,
judgment?
covered, my lords. Kindly have done. Next week, I'll take instruction and
Yes. Both the matters list on 20, list on 14th.
yes, please.
14. Land counsel appearing for the petitioner submits that these matters are covered by the judgment of a coordinate bench of this court dated 10th December 2025 and writ petition number 105933 of 2025 and batch. Yes.
Both the cases I take notice. In both the cases I take notice.
Both the cases. Yes, 32.
Case number 32. BC Dhanaya Swami.
Petitioner, my lord. The petitioner, your worship, here in challenge, the order passed by the senior civil judge and JMFC
Page number?
Unugund, my lord.
Number.
Page number 76, my lord. 75 and 76. The order passed on IA number 3 in RA number 17/2022. The
You are the,
my lord,
you are the appellant in
I
the
am the respondent before a trial court, my lord. I filed a suit against the respondents before lower court. The suit came to be decreed. Suit for specific performance, my lord.
is dismissed.
No, it is allowed. I filed a suit. After your lordship, against the judgment and decree, the respondents, your lordship, have filed a regular appeal before senior civil judge Sunugund. And in the appeal, my lord, the respondent number 2.
When is appeal filed?
Appeal,
Appeal is of the year 2022.
please, my lord.
When is this IA filed?
IA is filed. Please, ma'am. On 8/4/2025, my lord.
Where is that affidavit?
Affidavit is page number 47, my lord.
Please read.
Please, ma'am. The respondent number 2, my lord, he has filed a IA.
Yes.
So and so. I am the appellant number 2 in this case.
So where is the affidavit?
Affidavit
is, yes.
yes,
50 is the affidavit. Please read affidavit.
50 is the type. Please, ma'am. I am the appellant number 2 in this case. I know the facts and circumstances. I know the facts of the case that I am the bona fide purchaser of the suit scheduled properties. I have purchased the suit scheduled properties through registered sale deed dated so and so. Since the said registered sale deed, the said properties are in actual possession and enjoyment at the time of submitting the appeal memorandum. Through oversight, my counsel was not mentioned the proposed amendments in the appeal memorandum. The proposed amendments are very necessary me to defend my case on the strength of till deed dated 17/9/2013. The said proposed amendment, I am seeking remand of the case, seeking permission to submit written statement before the trial court under the principle of natural justice and equity. Hence, proposed amendment are essential to determine the real controversy between the parties before the trial court. Your Lordship, before the trial court, my lord, the present applicant, my lord, the respondent number 2. Your Lordship,
Please come to the impugned order and read.
please. Para number 8.
Yes.
Your Lordship, he is seeking amendment to your Lordship, para number 22 and 26, my lord.
What is going to happen if he seeks
If
amendment?
your Lordship, the para number 26, my lord, is seeking for remand of the,
Because he sought for it, it is not going to happen. The court will decide whether he is entitled for it or not, isn't it? Court has rightly considered that application. Now, whether he is entitled for remand, whether why he has not filed the written statement, whether he is entitled for filing the written statement, all are the merits of it, it will be considered.
yes, exactly, my lord. But the remand of the matter, your Lordship,
No,
which would
court
not,
has not asked to remand you. That's only his plea. Will it be considered by the court? Court will consider it after hearing your arguments and all. He is only permitted to amend the appeal memo. That's it. There is no prejudice to you because court is not going to do anything. Court will hear it on the merits of the matter. Please come. Agreed with orders passed in I number 3 in RA number 17 of 2022 dated 24/11/2025. The plaintiff respondent is before this court. The petitioner herein, who is a plaintiff in the suit, has filed a suit for specific performance of the agreement of sale. The said suit came to be decreed. Against that, RA number 17 of 2022 is filed by the purchaser of the property. Thereafter, this IA number 3 is filed under Order 6, Rule 17, seeking permission to amend the appeal memo as mentioned in the application. In the amended, by way of this amendment, what is sought to be introduced is that he has not filed the written statement before the trial court and he wants the court to remand the matter. The appellate court, by order impugned, has allowed the application. The court had considered the scope of an application under Order 7, Rule 11, and also what would be the prejudice that would be caused to the respondent if that is allowed. The court has observed that the appellant defendant wants to insert some facts in the appeal memo. It is what he wanted to insert is that he is a bona fide purchaser, but he has not filed a written statement. And he wants the matter to be remanded. It is a contention of the plaintiff that it is barred by limitation. And such a plea cannot be allowed. The court observes that whether the right of filing a written statement is barred by law or not, it has to be seen at the time of disposing of the appeal and not at this stage. In the case on hand, the appellant number 2 wants to seek the relief of remand and it cannot be denied to the appellant number 2. Further, if the appellant number 2 is not permitted to amend the appeal memo, then the appellant number 2 will be put to untold hardship which cannot be compensated in terms of money. And on the other hand, the respondent will not be put to any hardship. Accordingly, the court has permitted the respondent to amend the appeal memo. Next paragraph. Learned counsel appearing for the petitioner submits that when he has not filed the written statement, the court cannot permit him to file the written statement and remand the matter. And the court cannot allow the respondent to amend the appeal memo. The court had failed to consider the scope of Order 6, Rule 17 and allowed the IA number 3 that's filed by the respondent herein. It is submitted that the order impugned needs to be set aside. Anything else?
yes,
Having heard the learned counsel for the petitioner,
only
there is the material on.
the trial court, my lord, independently decide that observation, please.
Having heard the learned counsel of the petitioner, there is the material on record. The petitioner before this court is a plaintiff. His suit for specific performance is declared. Against that, an appeal is filed. Now, by way of this application, that's IA number 3, the respondent wants to amend the appeal memo by inserting that he didn't file the written statement before the trial court and he wants the matter to be remanded. If the memo is amended, it is not going to cause any hardship, prejudice to the petitioner for the reason whether he is entitled to file a written statement, whether the matter has to be remanded to the trial court, or the issues that will be decided by the court at a later stage after the parties adduce the evidence before the court. By allowing the respondent to amend the memo, no prejudice is caused to the petitioner. The court had rightly considered all these aspects and rightly held that, rightly allowed the application. In that view of the matter, this court is passing the following order. This court do not find any reasons to interfere with the well-considered order passed by the appellate court. Number two, with regard to the issue of remand, written statement, all other issues has to be decided by the court independently, basing on the evidence, arguments let in by both the parties.
Seal number 33?
Yes.
My lord,
Ahead.
if one intervention, my lord. My lords stated in evidence, my lord, it is not a suit, my lord, it is a array, my lord.
And it's a continuation of the suit. Basing on the evidence, the court will decide. Now, court has not given any finding.
Yes.
Now, if the matter has to be remanded to the trial court, there should be a reasoning for that. Why it wants to do. Because he has amended the appeal memo, that would not be the reason. Court has to give an independent decision on that.
Yes.
Yes.
Seal number 33?
Petitioner has challenged the externment notice issued by the sub-divisional magistrate, my lord,
Let's see.
under section 58 of the Karnataka Police Act, my lord. The notice is issued on the basis of the report by the police inspector. Therefore, that is my contention is that it's vague and illegal, my lord. That's covered by judgment, my lord. That's
My lords, issuance of notice, it is a premature, my lords. Now, notice issued under section 58
Under
of the
which-
Act,
let us-
Karnataka
let us
Police
look
Act.
at the manual.
Yes.
What is that provision?
58 of
Provision
the
58, my lords.
section 58.
It starts
What
from
is
section
Karnataka Police Act.
Karnataka Police Act.
Yes,
please.
That is 50?
58, my lords.
Let us read 54 first.
Please.
Yes, they have to conduct inquiry. The sub-divisional magistrate has
District
to conduct.
magistrate.
My lords, it's a
award
case
or
of
apportion compensation
55.
amount.
Thereafter, they have to issue the notice. In this case, my lord, without conducting any.
Let me look at the provision first. Disposal of gangs and bodies of person. Whenever it shall appear to the city of Bangalore, the race for which a commission is appointed. Magistrate or the superintendent is specifically empowered by the government. So what is issued in this case is a notice to you.
Notice
A
only.
notice.
It is on the basis of the report submitted by the police inspector. On the basis of the old cases, that is in
So
two cases.
whatever it is, you will go and explain to them.
In two cases, the petitioner is acquitted. On the basis of that cases also.
Whatever it is, there is no
No,
imminent danger to
they will
you.
not give an opportunity. Yesterday, this matter is posted before the sub-divisional magistrate. They are threatened to arrest the petitioner, my lord.
Now, under section 58, there
Please.
is a right of hearing for you.
Please,
Is
not
it
given hearing, no, opportunity not given.
what is notice?
Notice is given on the basis of the police report, my lord. They have to conduct, sub-divisional magistrate has to conduct independent evidence and the opportunity given to the petitioner. Thereafter, they have to issue the show cause notice.
Read 58.
Yes, I gone through the 58.
Let's read it.
But on the basis of 55,
You have seen it, but I have to understand it.
Please.
Please read 58.
hearing to be given before an order is passed by the under section 54, 55. There the no opportunity not given to the petitioner. On the basis of the police inspector report, the same is reduced in the
There is
notice.
no
madam.
order passed as of now. When
No,
notice is
madam.
due.
55, 54 says they have to give opportunity before issuing the so-called notice. Sub-division has to conduct the independent inquiry.
Where it says, please show.
Please, 55. For that, my lord, I have
Yes.
relied upon the.
Let's not go to the judgments. Let us read the provisions.
Well, let us read
55.
provisions
Yes.
58.
Ah.
58 is very clear. May I read, my lords? Before an order under section 54, 55 or 56 is passed.
What? It is very clear.
Yes, ma'am, it's very clear. This is only a show cause notice. He can, my lords, participate in the proceedings and he can raise any such defenses which is available for him. And
Madam,
thereafter, my
55.
lords, even after the order passed under section, my lords, 54,
No,
55,
they
56,
says that-
there is a appeal provision.
In every hearing, they says, I will arrest you and remove from the this district.
We can't anticipate things.
My lords, even he is not satisfied with the my lords,
Yesterday, the
order
matter is
passed.
posted before the sub-divisional.
There is a, my lords, appeal provision under section 59 of the Act.
To whom?
To the government, my lords. Section 59, appeal. Any person aggrieved by the order made under section 54, 55 or 56 may appeal to the government within 30 days from the date of such order.
Yes.
Removal of the, I am reading 55. Removal of the,
No, before an order is passed,
Please.
under 54, 55
yes,
or
they
56.
have to follow the procedure. They are not following the procedure. That is what I am, my contention.
Give the judgment. I'm not convinced.
Please.
Take that. Yes, read.
Para 6, ma'am.
Yes. Yes.
It is provided under section 58 of the Karnataka Police Act 1963 that before an order under section 54, 55 or 56 is passed against any person, the officer acting under any of the said sections or any officer above the rank of an inspector authorized by the officer shall inform the petitioner person in writing of the general nature of the material allegations against him and give him a reasonable opportunity of tendering an explanation regarding them. No doubt, the sub-divisional magistrate caused the notice to be issued to the petitioner under section 58 of the Act. However, the notice in question does not specify as to under which sections, whether under section 54 or 55 or 56, he proposed to take action against the, in this case also that is not mentioned in the notice manual. He proposed to take.
You tell all this to the police who has given you this notice, that your notice is, these are all the laches, lacunas. You can't come to the High Court on a notice.
No, ma'am. What happened, my lord? The inspector has to give opportunity to the person. Thereafter, the sub-divisional magistrate to give the opportunity to the petitioner. In this case, both are not done by the officers.
Please come. The present petition is filed, seeking the following prayer. The facts of the case are: the petitioners are resident of Murdeshwar. The police issue notice under section 58 of the Karnataka Police Act.
Subdivisional
Police no.
magistrate, subdivisional magistrate.
Police not issued.
No,
Subdivisional.
Assistant Commissioner and Subdivisional Magistrate are issued a notice under.
No, that's what
Sec-
you have stated, sir.
No.
I'm looking at your affidavit.
Not
petition.
police. Respondent 2, man.
Respondent number 2 have issued the notice under section 58 of the Karnataka Police Act and section 55AB for the externment of the petitioner.
Yes.
It is a case that the notice is issued on the basis of the old acquitted cases. Hence, the notice is vague, unsustainable under law, and the same is liable to be quashed. It is stated that the petitioner are not involved in any group fighting, as alleged by R4. Hence, the notice is against law. It is a case that the R4 is the inspector of police.
My lords.
R4 is inspector of police.
Yes, please.
R4, inspector of police, made false allegations against the petitioner. The R4, not conducting the investigation, submitted the false report to R2. And the respondent number 2, on the basis of the false report, issued the notice. Hence, the notice issued by the R2 is illegal, unconstitutional, and the same is liable to be quashed. It is submitted that the procedure that is adopted by the police is contrary to section 54, 55, 56, 7 and 8 of the Karnataka Police Act 1963. He has relied on, the counsel of the petitioner had relied on the judgment of the court in Udandappa Hanamappa Pujari versus State of Karnataka. Where is it reported? What is the citation?
Report.
So and so.
ILR reports.
To get it.
Page number 312.
312. Reported in 1985. ILR Karnataka, page number 311. Relying on this judgment, Land Council submits that the court has failed to follow the respondent number 2 has failed to follow the procedure, and the notice needs to be set aside. Next para. Learned Council, Learned AGA, appearing on behalf of the respondent, submits that this is a notice that is given to the petitioner as per section 58.
Yes.
If the petitioner feels that the respondents cannot issue a notice under 58, or there are any latches on the part of the police in giving a notice under 58, he can submit his explanation to the said notice. And if the police pass any order is passed, he has a right of appeal under section 59 of the Karnataka Police Act 1963 to the government, to the government. It is submitted that it is a premature writ petition, and there is no illegality with the action of the respondents in issuing the notice, and the present writ petition has to be dismissed. Next para. Having heard the Land Councils on either side, peruse the material on record. Section 54 of the Karnataka Police Act 1963 deals with dispersal of gangs and removal of persons convicted of certain offences. Section 54 deals with, Section 55 deals with removal of persons about to commit offences. 56, removal of person convicted of certain offences, wherein the offences are enumerated. Then 57 deals with period of operation of order under section 54, 55 or 56. And section 58 provides for a hearing to be given before an order is passed under section 54, 55 or 56. The submission of the Land Council that such a notice given is bad and the proper investigation is not conducted. When section 58 provides for a hearing, the whole purpose of that is to understand what is the defense of the person, and And according to the petitioner, basing on the earlier cases, they have issued this notice basing on a report of R4. If that is so, when a notice is given to him, it is always open for him to say that the notice is bad, that is contrary to the provisions under section 54 to 56. 56 will stop. But the petitioner cannot come before this court, and the judgment that is relied on by the petitioner does not lay any ratio as submitted by the petitioner. This court do not find any this court do not find any reasons to interfere with the notice that is issued by the police and the
Not
police
the respondent two.
by the respondent number 2, by the respondent number 2. Number 2, even if an order is passed, still the remedy available to the petitioner is to file an appeal under section 59, but he cannot invoke the jurisdiction of this court under article 226 of the Constitution of India. Hence, in that view of the matter, this court do not find any reasons to interfere with the notice that is issued, and accordingly the writ petition is dismissed, giving liberty to the petitioner to give his explanation and avail appropriate remedies available to him under the Karnataka Police Act 1963.
Maybe disposed of. Disposed of. Another meaning will come. Disposed
No,
of it.
because I'm not interfering, it is dismissed only.
Disposed of.
Disposed of.
Please. Connected matters pending.
There are connected matters.
Please.
Take those matters on Monday or Tuesday. Yes, next.
34, Second Arvind Pachapure. This matter.
The petitioner, my lords, is a proprietary concern, my lords.
What is this writ?
But here, my lords, the commodities were seized.
Let's
But
see the
annexure F and L are the impugned orders. They are in the local language, my lords, in Kannada language. But I'll just narrate, my lords, the facts. 2004.
respondent number 3. Who is respondent number 3?
Respondent number 3, my lords, all government elements.
No, 3.
1, 2, my lords, 5 are government.
Deputy Commissioner, the Department of Food and Civil Supplies.
Yes.
Now, this is the order passed by respondent number 3.
Yes.
What is the remedy against that order?
No, what has happened, my lords? There is a criminal case, my lords. There, my lords, there is an acquittal order in favor of this petitioner. And now, my lords, as per the provision, my lords, they are required to release the commodity which was seized. But initially, my lord, there was an interim order passed by the Deputy Commissioner releasing partial the commodity. 2014 is the seizure. But 2014. But then, my lords, a complaint came to be lodged.
Then why are you, what were you doing from 2018 till now?
No, acquittal, my lords, was in 22. 22, my lords, is the
We're in 25 now.
No, before that, my lords, 2000 quintals was released.
Let
It
them
is
come up with objections.
Please.
The respondent shall file their objections. Yes, next 35.
Seal number 35. Radhikan Gudwala.
Petitioner. On defendant's number 2 writ petition, my lord, application under my lord, order 6 rule 4 was filed. The lordship may kindly turn to ink page 71, para 5.
Page number?
71. An application seeking cancellation of compromise decree was filed. My lord, the application was filed. Para 5, ink page 71.
What is wrong with this?
My lord, order is, my lord, page 72. It is hereby ordered that an inquiry is to be held to prove the fraud being, my lord, for inquiry. This was the order. Ink page 76,
Yes.
para 4, page 76, para 4.
Yes.
My lord, on the said day, my counsel said that I have to no lead, I have no evidence to lead the evidence. Paragraph 4. It is necessary to consider IA number 16 defendant sought for recalling the compromise dated so and so by contending it was obtained by fraud. This court by order dated 11/4/25 by relying the decisions of Honorable Supreme Court in so and so, I said it is to conduct an inquiry with regard to alleged fraud to be perpetrated by the plaintiff in compromise matter. On 16/4/25, so and so for the and so advocate for defendant submitted.
So what the court is supposed to do?
My lord, my lord, I could not reach in time. My advocate said that I had no evidence to lead it. Therefore, I have made a complaint to Bar Council that I had not instructed. My lord, court passing an order that plaintiff is, my lord, defendant is absent, taken as nil. That is one thing. My advocate, my lord, himself,
Complaint given against the advocate?
please, my lord.
Where is the complaint?
Oh, it is filed in Bangalore.
No, where is it? Where is a copy of?
No, it is not. On instructions I am making submission.
It will see, because this is not the way we deal with the cases.
No, without instruction, my lord, the advocate has made a,
Let's see the complaint given by you.
please.
This is matter on 28th January.
28.
Yes. Next.
Seal number 36. MC Utkeri. 36. MC Utkeri.
No representation listed in the month of February.
February.
Yes, 37.
Seal number 37. Harendranath Deshpande. HR Deshpande.
And for the petitioner, my lords.
Yes.
The petitioner has sought for the directions to the trial court to dispose of the IA1 along with the,
To dispose of the IA.
to
When was it
dispose of
filed?
the IA before
What is
hearing
this
the
IA for?
arguments.
IA for?
IA was for amendment to incorporate that the sale deed executed between six,
What was the IA filed?
that was the IA file for
When
amendment,
was the IA filed?
my lords,
When was the IA filed?
during the pendency of the appeal itself.
No, to understand, you are seeking an expeditious disposal of the IA. When did you file it?
My lords,
No. Seeking a direction to dispose of IA number 1 of 2025.
Yes.
I'm asking you, when did you file? What is the date, month?
it was filed on 23/7/25,
23?
7/25.
Ah.
That's at ink page number 35.
Let us see the proceeding sheet.
Ink page number 35, my lords.
You are the
I am for the plaintiff,
appellant.
appellant plaintiff.
Let's see from 23/7/2025 what happened.
On that day,
Appellant, the council present files IA number 1
Yeah.
under order 6/70.
and
amendment to the plaintiff.
ink page number 33 may kindly be gone, my lords.
Then 16/8/2025.
Ink page number 33, that is the typed copy of the order sheet.
A number along with main appeal. If the court said IA number 1, it will be decided along with the main appeal.
Along with the main appeal,
Uh,
because it is an amendment.
Seeking what is the amendment you are seeking?
Amendment was sought that the sale deed executed by the defendant 6 to 8 in favor of defendant number 5 is not binding on the plaintiff, because it goes to the very root of the case. Unless the pleadings are settled, the entire appeal cannot be disposed of. That was,
Need to issue notice in this, because this is not the court has already passed an order to decide this along with the main appeal.
along with the main appeal.
Notice to the respondent, and that the petition is permitted to take out hand summons on the.
And in the meanwhile, I sought for interim order of stay, my lords.
The council,
Because
the,
it's,
the petition is permitted to take out hand summons on the council appearing for the respondent and shall file a memo to that effect. Once the memo is filed, list the matter.
it's already posted for respondents' arguments, my lords.
We will, if you take the memo and file it next week, we will list it next week. Yes, 37.
Number 38. CH Bagi.
Yes.
Please.
Lords, the
Yes.
petitioner is questioning, my lords, Annexure J, my lords. Annexure J, my lords. Lords,
What is
the,
Annexure J?
please, my lord, they have issued, my lords, a notice to auction sale, e-auction sale, my lords. E-auction sale.
So why they shouldn't do it?
My lords, before that, my lords, the page, kindly see at page 78, my lords, this honorable court has directed the, my lords, the consider OTS and hand over the possession, my lords. Kindly see at page number 78, my lords, annexure. F2, my lords.
Annexure?
F2, page 25, and 78 is my operating portion. Para 7, my lords. 5 and 7, my lords.
Should also submit a representing one-time
The-
settlement, but this court cannot issue mandamus if such representation is open for the bank to consult the same. Petitioner already deposited 24 lakhs out of 39 lakhs.
Yes, my lord. Instead of, my lord, again, they are redelivering the possession and without considering that, my lords, they are issued an exercise, my lords, once again, conducting e-action sale.
Court only said consider.
Please, my lords.
They have not considered.
They have stated, and I challenge that annexures, my lords, they have issued endorsement stating that, my lords, they have to pay again 36 lakhs. That is annexure, my lords.
Please understand.
Please.
We cannot consider all these aspects unless until the respondent is before this court. Which is the respondent?
Lords, respond number 2, my lords.
Who is whatever SMFG India
Please.
Home Finance? Take out enhancements.
Lords, because auction is fixed, my lords.
What is wrong with the auction? That you tell.
Lords,
us.
we are already, lords, this is the fourth time, lords, they are fixing an auction, and we have deposited around more than 24 lakhs, lords,
Not
out
about
of
more than 24 lakhs. Whatever is outstanding.
the only
you have to
remaining
pay.
outstanding, lords, only 15 lakhs as per them, lords. And this court,
Paid then on that I'll grant stay.
but they have said, well, issued again 36 lakhs. Well, kindly see at page annexure H.
Who say
Annexure H.
limited amount is 15 lakhs. You pay 15 lakhs, on that we will grant stay.
Lords, out of that, lords, 25% I will pay that, remaining 15%.
But I will not interfere in these matters because the High Court has no business to interfere in these matters without any legal ground.
Well, 50% at least, lords, because I'm not, if you are calculated, it comes around below 10 lakhs, lords.
I will take it up tomorrow.
Sorry, lords.
You calculate, I will take it up tomorrow. What is
Lords,
the
instead of
amount?
that, lords, 50% I'm ready to pay, lords, deposit, I'm ready to deposit 15 lakhs, so around 7 lakhs it's come around.
With these High Court orders, how many times we will interfere with this?
Lords, already they have directly, clearly directed, lords, that as per outstanding, there is a due amount, it says that only, that is 15 lakhs, lords. But again, they have issued one more issue notice that stating that, lords, 44 lakhs. The since from the fourth notice is also same 40 lakhs. Kindly say, my lords, I have how deposited at annexure A, page 42, my lords. Everywhere, lords, they have not at all deducted the whatever amount deposited.
The light of the settled law, unless and until the bank agrees for it, there cannot be, we cannot, you are not entitled for the redemption of mortgage. Once a sale notice is issued, isn't it?
Lords, the grievance is no, the only that, but they are not deducting the whatever deposited amount. Anyhow, my lords, I have to, I agree with you, my lords, 50% out of 15 lakhs, my lords, I'm ready to 7 lakh rupees, I'll deposit, my lords, that interim order will be granted. You of that, my lords, because the possession is already have taken, my lords, they are out of the,
They have not given the position. Just now you said they have not given the position.
they have not given the position. Even though court has directed, my lords.
Then you are not in possession of the property.
That's the reason, my lords, I approach for the court, my lords.
Auction is conducted also when they have already position is with them.
Please.
No threat to you. If they let
No,
you
again, my lords, the multiplicity.
conduct the auction, if whatever reasons you say are valid reasons and that is bad, we will set aside the auction.
Well, instead of that, my multiplicity, instead of that, my lords,
Be served. No purpose would be served in staying this by paying that much.
well, e-action, at least e-action maybe position is concerned, my lords. I agree with that.
I can understand if the position is with you.
Please.
Admittedly, position is not with you.
Please.
Auction notice is issued. Whether auction conducted, not conducted, ultimately whatever the order that is going to be passed by the court would be basing on the merits. It won't, the circumstances won't change.
But instead of that, at least e-action sale.
Registry is directed to issue notice and the petition is permitted to take out
My lord, sir.
and summons on the respondent and file a memo.
My lord,
Once the memo is filed, list the matter.
My lords, I submit, my lords. Instead of that, my lords, that next J may be stayed and subject to the, my lords, deposit of, my lords, 50, that is 5 to 7 lakhs, my lords. Then take, see, Angadi is appearing for the bank, my lords, take notice for them, my lords.
How are you going to be in a better position? That you please tell.
Well, at least, my lords, that the procedure will be stopped, then the OTS scheme, my lords.
If they have issued a demand, if they give the action notice without considering the amount that is already paid, we will anyhow set aside, set that auction aside. Yes.
No, sir. Angadi is not appearing. Sachin Angadi is there to take notice, my lords. He is appearing for Sachin Angadi.
Petitioner is permitted to serve notice on Mr. Sachin
Angadi.
Angadi and file a memo. Once the memo is filed, list the matter.
Plus on Monday, because 13, Monday. I'll serve copy to him.
Seal number 39, DC Gnanaya Swami.
No, instead of saying hand summons and all, just say petition is permitted to serve notice on Sachin and Sunday. Yes, yes.
Lordship, please kindly short accommodation. Lordship. Kindly have it on next week, Lordship, please.
Yes, next week.
Please.
Yes, 40.
Number
For
40.
petitioner, my lords. Because this is a tender matter, my lords. This is a tender matter that's challenging additional qualifications that has been imposed by respondent, my lords. That is only 8 conditions have been imposed, my lords, qualifications. That we are challenging only 2 conditions, my lords. On the ground, my lords, 1.
Let's see the conditions.
Please, my lords, it's page number 29, my lords.
Yes, it's in Kannada.
Please, the translated copy is here, my lords.
Give that.
Lords, one of the conditions, my lords, at serial number 3, my lords, is that
What is the tender for?
Lords, the tender is for transportation of my lords, milk powder as well as my lords, ragi malt for the period of 2 years, my lords. Now, in
From where to where?
Lords, in the vicinity of respondent, my lords, it is the milk union. Lords, that is a respondent, my lords, that is.
Let's read the conditions.
Please. Lords, the condition number 3, my lords, is that 50 lakhs insolvency certificate has to be produced.
50 lakh solvency certificate as well.
Solvency certificate has to be produced by the the person who is to bid for the tender, my lords. Lords, this condition has been imposed on 23/12/2025. The initial notification for tender, my lords, was released on 5/12, my lords. That time they could have imposed this condition. That is point number 1. Lords, point number 2 is that this certificate is given to the any person, my lords, by the respective financial institutions, my lords, that is bank, which cannot be obtained within the span of 15 days. Because once we make an application to our respective bankers, my lords, they'll have to verify our books of accounts, my lords, our total assets and liabilities, our
What about the 6?
let's point number 6, my lords, that at least the person who is intending to, my lords, bid for the tender has to produce a certificate, my lords, for having shown that they've worked in 2 unions prior, that is the respondent unions. Lords, if these conditions are imposed, lords, there's only one company which again will be the let's get the tender for the
When was the
corresponding.
auction notification issued?
Sorry, my lords.
When was the auction notification? First notification.
Lords, it is on
issued?
5/12, my lords. Annexure A, 5/12.
2026.
2025,
When is this, when is this amended one?
My lords, on 23/12.
23?
12.
When is the last date for
Applying
the last date for submitting the application?
today, my lords, at 5:30, my lords.
Then what were you doing?
Lords, now, except, my lords, this condition number 3, the solvency certificate, which I've already applied to my bank, that is not possible because I've already produced all the documents for them to issue me a certificate, my lords. I'm awaiting that certificate. I will produce once that is issued, my lords, within the span of 2 weeks. Lords, because it will normally take 15 to 20 working days, my lords. That I am ready to comply with that condition also. Lords, insofar as condition number 6 is concerned, lords, I've already undertaken services, my lords, in other governmental organizations, Food Corporation of India. Now they are demanding, my lords, I should have worked prior in any of the unions of respondent, my lords. How is that possible, my lords? If I'm a first-time bidder,
Organizations,
please,
any organization.
not organize. It's the union. Vakkutagalu is a union of respondents, my lords, which is there at different places all over Karnataka.
I'm reading.
Please.
I'm reading at what you have.
Please, let's may I read. Let's ಕನಿಷ್ಠ 2 ಒಕ್ಕೂಟಗಳಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸಿದ ಸೇವೆ ಪ್ರಮಾಣ ಪತ್ರ.
Service satisfaction certificate of at least 2 organizations.
Union, let's Vakkuta is union, my lords, and got it translated, my lords. It is union. Let's may kindly see the respondent, my lords. Respondent is a milk union, Raichur, Ballari, Koppala, Vijayanagara District Cooperative Milk Producers Societies Union Limited. They are seeking, my lords, experience certificate from the petitioner or anybody who is intending to bid, my lords.
Let the auction go on.
Please, I'm not seeking to stay on the entire auction, lots. I'm ready to produce the solvency certificate, lots, once I've received it. Lots, insofar as all the other conditions I've satisfied and I've complied.
Now, if they want it to be within the organization, what is wrong with that? The person who is issuing the notification.
Lots, now if this condition,
because you are not fulfilling the condition, that does not mean that at least 50 lakhs that one, if you say that I want time and because of this lack of time you are not able to do it, That we can say, as on today, as on notwithstanding the fact that you are not complying with 3 and you will do it at another 1 week, we can do it. But number 6, how can you say that, what is wrong with that?
Now, if any first timers who intend to apply for the tender, at least for providing of services as transportation as contended, I will lose, and there is only one company which satisfies this condition number 6.
That's a different aspect. What is wrong with their, they have their own criteria.
Now, if I'm inexperienced, is another issue, Now, I have been providing services.
We can't tell them that you keep a condition that in any place they must, any experience anywhere is sufficient.
Now this is a unilateral condition, because there are no competition itself, or there is no other companies which falls under this domain, because there's only one company which has been receiving this tender for the past 6 to 8 years, in the same union. Now, if any other person, who intends to file for the tender also for participation, I lose my chance of even
To hear the other side, what is it?
Now 5:30, what can I, that is my suggestion, I pray to this honorable
Are they
court.
opening the tenders?
On 12,
12th of this month.
Yes, 12th. What has happened here also, insofar as all the other conditions, qualifications that has imposed on initial notification of 5:1 and 5:12 and 23:12, all those have been complied.
One thing the court can say, as far as the 50 lakhs insolvency thing is concerned,
Please.
without considering that your tender to be taken.
Please, now the issue,
6, I will not interpret.
Also the issue is, that this is a transportation of milk powder and ragi malt and all this food grains. I've also produced my Udyam certificate, wherein I'm registered in that domain also, which is issued by the government of India, and my services to other semi-governmental organizations with regards to the same food grains, PDS, I have the certificate of experience.
That is not the concern of the court.
But this only makes sure.
Who is issuing the notification to fix up their own standards?
But this unilateral, it's only favoring one company, There's no other company which is coming near to it also,
No, that's what is the standard they want. They want the people to understand how they run the business in their unions.
It is transportation which is unloading and loading, which the petitioner is already doing in the other organizations.
You know the scope of interference of the court in tender matters.
No, I'm not intending or seeking any stay of the entire tender process. I'm only seeking permission for issuance of the solvency certificate, submission of the solvency certificate, and insofar as this condition.
But I said the court will, that as far as that order is concerned, I can grant, but 6, I'll not interfere without hearing the other side.
At least I may be permission may be granted for me to apply for the tender, because they will outrightly reject my tender itself on the basis of this, because you have not worked in any other unions.
Only 3.
6 also, because this
What is the purpose?
This is favoring.
3 is something which you'll be able to comply.
Yes.
6 you cannot comply. So what is the
the competition itself goes away, and there's only one company, that is, this conditions have been imposed after the gap of initial notification, so that it can be favored for a company.
As for the tender conditions, they have every right to modify the conditions. That also
But they're not. They've only, insofar as there was one more requirement, that the vehicle that is used for transportation should be should have the capacity of more than 20 metric tons, as well as that the vehicle should be of about 2016 vehicle. That condition also is now fulfilled by me. That was an only changed modified condition that was made by the respondent.
Want that order can be passed, but not 6.
Not insofar as 6
Once
is.
6 is not granted, even if I give you, if the 3 is the court grants a direction, still your application will not be considered, because 6 you're not fulfilling.
Please, that is a unilateral condition,
Let them come, we will see.
At least I may be permitted to apply insofar as 3 is concerned. I'll make a representation to the respondent.
The initial auction notification was given on 5/12/2015. In that, the clause number 3, that is 50 lakh solvency certificate has to be obtained and uploaded, was not there. Then this has been amended on 23/12/2025. It is submitted that to get the same, it requires at least 3 weeks time.
Please, 15 to 20 working days.
15 to 20 working days from the bank. In those circumstances, it is a short notice. The petitioner is not in a position to fulfill condition number 3. However, as he has applied, he would be getting getting the same, in view of the same, the respondent are directed to accept the petitioner's tender, notwithstanding clause number 3, which will be submitted by the petitioner within a period of 1 week from today.
2 weeks limits. I've already applied.
So you install that.
No, indeed not, minutes. I will produce the certificate is to be issued by the bank minutes. I've already made all my
Unless and until you give it with the open,
please minutes.
by 12th you have to do it.
I have already made my application to the bank minutes. They're verifying my
You have to-
documents.
That's not their problem, no. By 12th,
now-
by 12th January, the petitioner shall submit the same. Notice to the respondent. Yes, next. Give that. Give the list. Yes, getting late, 1:35. Yes.
My lord.
Number 41.
Lord, challenging annexure A, my lord, the tender notification, my lord.
Can it wait? Can it wait till tomorrow?
My lord, they may issue work order at any time, my lord. Financial bid is open.
Because I'm getting late, there's a.
Please.
Tomorrow, 41 tomorrow, next 42.
42.
Any
be taken.
urgency in 42?
Chandramali, 42.
Any urgency?
Can be taken tomorrow, my lords.
Tomorrow or Monday?
No, tomorrow, my lords.
Tomorrow. 42 Monday, 43?
Madam,
43?
may kindly be posted tomorrow itself.
Tomorrow
Please.
is 44?
Lord, it is
44?
urgency, my lord. It is a matter of the termination of pregnancy, my lord.
Tomorrow?
Tomorrow.
Yes.
45.
Other matters are all
No, I
old
just want to
matters.
make one submission.
Interim order
In
is
40
required to be.
In
All the
45.2,
matters, wherever interim orders are there, please extend the matters. Remaining matters.
no, I just want to,
Give dates. Yes.
in 45.2, I want to withdraw the writ petition.
Yes, take that.
45.2, 45.2.
45.2, a memo is seeking to withdraw the petition, dismissed as withdrawn. Huh? You know, if you want to withdraw, let them withdraw.
No,
Other
it's
matters
only in respect of 45.2.
Yes, I understood that.
Yeah.
So remaining, give the dates
Yeah.
in third week.
Please.
ಐವತ್ಮೂರು ಮೇಡಮ್ ಮೇಡಮ್ 53 ಎರಡು ಅಲ್ಲ ಅದು MFA ಅದು ಮತ್ತೆ ಕನ್ಫ್ಯೂಸ್ ಆಗಬಾರ್ದು
45.2, sir.
MFA ಅದು ಫೈನಲ್ ಇಯರಿಂಗ್ ಬಂದಿರೋದು
Sir. Sir. Connected matter ಒಂದೇ.
ಇವತ್ತಿನ ಡೇಟ್
47. Interim order action ಆಗುತ್ತೆ. Date ಇಲ್ಲ. 51. ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡ್ತೀನಿ. ಡೇಟ್ ಅಲ್ಲ ನೋಡ್ಬೇಕು, ಅವ್ರು ಹೇಳಿದ್ರು ಯಾವ ಡೇಟ್ ಬೇಕು ಕೊಡು ಅಂದ್ರೆ ಯಾವ್ದು ಎಂಟ್ರಿ ಮಾಡಿ ಯಾವ ಡೇಟ್ ಬೇಕು ಕೊಡೋದು ಇಲ್ಲ ಅದೇ ಥರ್ಡ್ ವೀಕ್ ಕೊಡು ಅಂದ್ರೆ ಡೇಟ್ 53 ಏನ್ ಬಿಡಿ ಎಂಟ್ರಿ ಮಾಡು. ಎರಡು ಇತ್ತಲ್ಲ 23 51 ಹಾ ಎಂಟ್ರಿ ಮಾಡೋ ಆಕ್ಷನ್ ನೋಡ್ತೀನಿ ನಾನು 51
ಎಂಟ್ರಿ ಮಾಡೋರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್
ಹಾ ಡೇಟ್ ಹಾಕು 23 ಹಾ ಎಂಟ್ರಿ ಮಾಡೋ ಹೋಲ್ ಬಿಡ್ರಿ ನಮ್ಮ ಮನಸ್ಸು ಬಿಡ್ತಾರ ನಾನು ಆ ದೃಷ್ಟಿಯಿಂದ ಹೇಳಿದ್ದೆ ನಮಗೆ 3 ವೀಕ್ಸ್ ನೋಡಮ್ಮ 42 ಅದೊಂದು ತರಿಸ್ಕೋಬೇಕು ನೋಡಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಸರ್ ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ ಸರ್?
ಇಲ್ಲ ಸರ್.
ಸರ್ ನಾಳೆ
ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್
ಸರ್ ನಾಳೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆ ಸರ್?
ನಾಳೆ ಇರುತ್ತೆ
ಸರ್. ಅದು ಒಂದು ಬೆಂಗಳೂರು ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ದು ಒಂದು ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡಬೇಕಾಗಿತ್ತು.
ಇಲ್ಲ ನಾಳಿದ್ದು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಇವತ್ತಿನ ಮಧ್ಯಾಹ್ನ ಮಾತ್ರ ಇಲ್ಲ.
ಅಲ್ಲ ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ದು ಮ್ಯಾಟ್ರ್ ತಗೋತಾರಲ್ವಾ ಮೇಡಮ್?
ಸರ್ ನಾಳೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆ ಅಥವಾ ಇಲ್ಲ ಇಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ. ನಾಳೆದು ಮೇ ಬಿ ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಇರಬಹುದು, ಕನ್ಫರ್ಮ್ ಇಲ್ಲ.
ನಾಳೆ ಮೇಡಮ್ ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಇರ್ತಾರ?
ಕನ್ಫರ್ಮ್ ಇಲ್ಲ, ಇರಬಹುದು ಅಂತ ನೋಡೋಣ ಸಂಜೆವರೆಗೆ.
ಸರಿ ಸರ್. ಸರ್ ಈಗ ನಿಮ್ಮನ್ನ ಕಾಂಟ್ಯಾಕ್ಟ್ ಹೆಂಗ್ ಮಾಡೋದು ಸರ್ ಮತ್ತೆ?
ಇಲ್ಲ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್, ನೀವು ಹಾಗೆ ಮಾಡಿ ಲಿಸ್ಟ್ ಮಾಡ್ಸ. ಆಯ್ತು ಸರ್, ಸರಿ ಸರ್.
ಸರಿ, ಥ್ಯಾಂಕ್ ಯು.
ಇದು 48. ಹಾ ಕಾಲ್ ಆಗಿಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಐತೆ ಅದ್ರೊಳಗೆ ನಾವು ನೋಡ್ರಿ ಕಾಲಾಗಿದ್ದಿಲ್ಲ ಅಟ್ಟ ಕೇಳ್ತಾರ ಅವರು. ಇವೆಲ್ಲ ಬಂದ್ ಮಾಡ್ಬಿಡ್ರಿ ಎಲ್ಲಿದ್ರದು.